Professor Dr. Sarfraz Ahmed Khan, the Director of Symbiosis Law School, Hyderabad, Professor T.C. James, the President of National Intellectual Property Organization, who's the chief guest for this occasion, our guest of honor, Dr. Suryamani Tripathi, the Legal Counsel at ICRISAT, Hyderabad, our special guests, Mr. Jatin Trivedi, the Senior Partner at YJ Trivedi and Company, Ahmedabad, Mr. Shishira Rudrappa, the Managing Trustee at IDIA, Mr. Amit Datta, the partner at Sai Krishna Associates and Advocates, Mr. Nihas Bashir, the partner at Vadia Gandhi and Company, and Professor G.B. Reddy, Professor of Osmania University. I would also like to take this opportunity to welcome our faculty in charge, Assistant Professor Dhania ma'am, and I would like to take this opportunity to finally welcome all the participants from all across India to the first symposium being conducted by the Center for Intellectual Property Research and Advocacy. Now, before we begin with the welcome address, I would like to take this moment to remember the achievements and remember the work done by Professor Dr. Shamnath Bashir, in whose memory we are conducting this national symposium. And so I would now like to ask our director, Professor Dr. Sarfraz Ahmed Khan, sir, to please proceed with the welcome address. So please.
Sorry, my mic was, yes.
Sir, before we begin with your welcome address, we will play the biography film of Symbiosis first.
Okay.
Sorry for the inconvenience, sir.
Sure.
You do the things you love, then you're ensuring that you don't work another single day. I guess I was just curious as a child, so almost any kind of knowledge that I got from it. This is the story of a man who dared to dream and persevere to make his dream come true. The story of one Indian who thought differently and made a huge difference to the lives of thousands of students all over the world. Dr. Majumdar, who was the rector of the boys' hostel, was spending a quiet afternoon in his quarters. All the students had left for the Diwali vacation. Only the foreign students stayed back. His attention was suddenly drawn by the sight of a girl student. She was standing under a window of the boys' hostel, secretly passing a small parcel to a boy inside. Suspecting some mischief, Dr. Majumdar went to the room to investigate. What he saw left him disturbed and distressed. The girl had gone to give some food to a Mauritian boy who was suffering from jaundice. The incident left a deep impact on Dr. Majumdar's mind and a deeper void in his heart. He was determined to improve the plight of these international students.
Symbiosis was born in 1971. It was the seed of a dream sown by its founder, Dr. Shantaram Balwant Majumdar. The dream was to create an educational institute where, in the words of Dr. Majumdar, students from all over the world would live, study, eat and play together in an atmosphere of peace and harmony and mutual respect and acceptance of the diversity of cultures, and go back as friends and ambassadors of this nation. Dr. Majumdar, himself a professor of botany, chose the name symbiosis, the word biologists use to describe a mutually beneficial relationship between two living organisms. The guiding philosophy behind the venture was Vasudhaiv Kutumbakam, the world is one family. Today, the symbiosis sapling has grown into a huge tree. In 2002, Symbiosis was given the status of a university. The first campus was established at Senapati Bapat Road in Pune. This is the headquarters of Symbiosis, with the 12-story high Vishwabhavan and the iconic statue of cartoonist R.K. Lakshman's Common Man. The campus is a landmark in the city. The constituents and departments of the university are spread over several campuses in Pune.
And indeed, Symbiosis has moved beyond Pune to other cities in the country as well. In the foreseeable future, Symbiosis plans to have campuses in other nations too. The university hosts thousands of students from
Each and every state and union territory of India, as well as international students from countries all across the world. The university has multiple faculties offering a bevy of wide-ranging programs.
The mission of Symbiosis is to promote international understanding through quality education. And we have students from different states of India as well as different parts of the world. Our thrust is not only to provide excellence in academics, but to mold personalities of these young minds who come to study with us.
Spectrum of programs offered at the university is truly wide, and it gives the student an opportunity to really take courses from each of the various disciplines, giving them an opportunity to learn across disciplines. And I think this is one of the most wonderful features of studying at Symbiosis.
The university's emphasis on research has resulted in the setting up of several support centers. The most significant effort in this direction was the setting up of the Symbiosis Community Outreach Program and Extension Activities, in short SCOPE. While the initial focus was healthcare, activities were later extended to include banking and finance, computer literacy, and legal counseling. Following the success of the SCOPE initiative, the Symbiosis Center of Healthcare launched a family doctor clinic and mobile medical unit in the Mulshi block of Pune district. Meanwhile, the university has adopted 14 villages and 9 hamlets around its lovely campus and helps villagers with health, education, sanitation and waste management issues. The university attracts a multitude of well-known persons, leaders, celebrities and iconic personalities as a part of Festival of Thinkers. What is less well known about Symbiosis is the wealth that Mother Nature has bestowed on it. The university campus at Lovely is home to a large variety of plant species. The university has already published a book on this, and now 2 geologists have published a book on the rocks of the Lovely Hills. Titled The Singing Rocks, the book puts visitors to this lush and sprawling campus in tune with the fascinating geology of the hills.
I would now like to take this opportunity to again welcome our Professor Dr. Sarfaraz Ahmed Khan, who's the Director of Symbiosis Law School, Hyderabad, and would like to request Sir to kindly give the welcome address. So,
Thank you, Navneet. A very warm good morning to everyone. Professor T.C. James, President of NIPO, Professor Dr. Shurya Mani Tripathi, Legal Counsel, ICRI SAT, Mr. Jatin Trivedi, Senior Partner, YJ Trivedi and Company, Ahmedabad, Mr. Shishira Radrappa, Managing Trustee of IDIA, Mr. Amit Datta, Partner of Sri Krishna and Associates, Professor Dr. G.B. Reddy Sir, Professor of Osmania University, Hyderabad, Faculty in charge of Center for Intellectual Property Rights, CIPRA, Professor Dhania K, my esteemed colleague of Symbiosis, all the presenters from different universities and practitioners coming from all over the country. My heartily welcome to everyone on behalf of Symbiosis Law School, Hyderabad. The National Symposium on Intellectual Property Rights is organized by CIPRA to provide national exposure to the students. CIPRA has been organizing various events since its inception in 2016, and Team CIPRA has actively contributed to the research and growth of intellectual property, various society-centric initiatives. CIPRA is organizing this symposium in the memory of Professor Dr. Shamnath Basir, very close friends of us. I am fortunate enough to work with him as a colleague at NUJS since he joined NUJS as a professor almost little more than a decade ago. Professor Shamnath Basir was an Indian legal scholar and founder of IDIA. Dr. Bashir was rated as one among the top 50 intellectual property personalities at the international level. He was appointed as the first intellectual property representative of India to Global Advisory Council and World Economic Forum. He had done a wide range of research in the areas of intellectual property and technology. We lost him at too early age. A person can think of living, but that's God's wish, and what we can only do is in the memory we are organizing these programs, and whatever his mission and vision was is all collective responsibility in whatever manner we can contribute to bring it forward. IDIA, his IDIA, I know the IDIA when it was born in NUJS. MP Singh sir was trustee, Rumapal was that point of time chair professor at Human Rights Center, and say immediately thereafter she agreed to be part of it. So these all formation stage from there. I closely know Samnath, we hearing every time. So this, as in we have a collective responsibility. I also feel I'm one part of it, have a responsibility that his mission and vision should continue, and whatever manner we can, his dream, we can make it true or successful. So with these few words, I want to thank all the guests and panelists for taking time out of your busy schedule to make this event successful. I wish all the participants and presenters a good learning experience in this symposiums. At Symbiosis Law School, Hyderabad, we have almost 19 centers and 9 cells through which we organize a large number of programs. And we throughout the year we have some activities, but this activity specifically we wanted to dedicate in the name of our good friend Professor Samnath Bashir. So with these few words, I welcome you again, and thanks for joining. I particularly am grateful to a representative from IDIA for agreeing for today's programs and being part of it. So it's give at least some opportunity for us to remember our good friends. With these few words, thank you, everyone.
Thank you, sir, for those warm words. Now, I would like to request Assistant Professor Dhania ma'am, who's the faculty in charge for the Center for Intellectual Property Research and Advocacy, to kindly give an introduction to what Team CIPRA is and kindly give an introduction to this national seminar that we have. Ma'am, please.
Thank you, Navneet. Am I audible?
Yes, ma'am.
Respected dignitaries, directors, sir, faculty members, students, and the industry people who have come to this national symposium. On behalf of CIPRA, I welcome all of you to this August gathering. The Center for Intellectual Property Research and Advocacy is an integral part of Symbiosis Law School, Hyderabad, which is established to develop research and advocacy skills in aspiring lawyers with special emphasis on intellectual property rights and promoting knowledge of this emerging field of law. Since its inception in 2016, CIPRA has been executing various activities in furtherance of its goals, which include encouraging research in every area of subject, promoting and spreading awareness about IPR among students and the public at large with special various practical approaches. In 2020, CIPRA had organized a webinar on innovation and IP, Innovate for a Green Future, and various competitions were organized to celebrate World Intellectual Property Day. The aim of this was to link intellectual property with green technology and to make the young minds understand the necessity of development in this field for a better future. Understanding the importance of intellectual property in business, CIPRA, in collaboration with Symbiosis Institute of Business Management, Hyderabad, had organized a guest lecture on business and IPR, commercialization of IP, and startup and IP. Center had also organized 2 capsule courses on copyrights and geographical indication and traditional knowledge, with an objective of giving a comprehensive idea of these important aspects of intellectual property rights to the students. We have been carrying on with various research and advocacy works related to geographical indication, and Team CIPRA has worked with Telangana government for a research project on geographical indication of the Balanagar custard apple. The recommendable work of the team was appreciated by the Agriculture Production Commissioner and Principal Secretary, Agriculture and Cooperation Department, Government of Telangana. IP Unveil, the flagship event of CIPRA, has helped to spread awareness among the students in the rapidly emerging domain of intellectual property rights and to engage them in different activities to enhance their knowledge. Broadly, the events consisted of academic IP, in order to engage the students with the academic aspect of intellectual property rights, IPOs to enable students to engage in discussion with their peers in relation to IPR and encourage peer-to-peer learning. Creative IP to stimulate the creativity among students and to engage them in the creative domain of IPR. To celebrate individuality and originality of thought, CIPRA presented Simbi Live with the aim of reignite passion in the law students. Continuing the legacy of involving the students, the center had organized two editions of Necessity, Caffeinate Your Confusion. The aim of this session was to create an avenue for young students who is entering into law school to gather and share their experiences with the senior students and learn more about IPR and various opportunities in the field of IPR. In furtherance, to keep the spirit of its inception, Center is organizing this national level symposium on intellectual property. We are dedicating this national symposium to Professor Dr. Shamnaz Bashir, who was a pioneer in the field of intellectual property rights and whose contributions will be everlasting in the Indian IP world as well as Indian legal education. The National Symposium on IPR on changing dynamics of IP for development will be the first in Symbiosis Law School, Hyderabad, and would seek to reach students, professionals, and academicians from all over the country. The main theme of the symposium is changing dynamics of IP for development. We have chosen this as the main theme as the role of intellectual property for the development of a country is well recognized now. A well-balanced IP system will benefit a lot of country as it has great impact on development through innovation and creative production. There are different types of intellectual property and each one of them contribute to the development process uniquely. The changing dynamics of IP witnessed in the last decades require revisit of the existing legal regimes and to bring them in tune with the development agenda both nationally and internationally. The symposium will be a one-day event consisting of plenary session and technical sessions on artificial intelligence and IPR, patent and technology transfer, geographical indication and protection of traditional knowledge, copyright and related rights, interface of human rights and IPR, and business and IPR. And we anticipate lot many discussions will be taking place during this one day. In the past 4 years, Team CIPRA has combined valuable work and has contributed to the growth of IP and its awareness in the society through various initiatives taken up and is looking forward to actively figuring out areas of development in this field of law. Team CIPRA has created a video to pay tribute to Dr. Shamnaz Bashir, and now I request Mr. Ramesh, our IT coordinator, to play the video. Thank you.
When you do the things you love, then you're ensuring that you don't work another single day. I guess I was just curious as a child, so almost any kind of knowledge that I got from anywhere kind of in many ways excited me. IP has been the main sort of core research interest for me for a large part. But to put it in a nutshell, the core area of my work is how do we build a more inclusive society using the tool of the law, because that's what I know best. And how do we build a more plural society? Surprise, shock. That was one of the few times that I couldn't, I was tongue-tied, and I said, well, you've succeeded in making a very loquacious lawyer tongue-tied. This will help leverage many of the causes that I've taken up, including access to education, promoting public interest lawyering, getting more students to participate in the courts, getting more academics to participate in the courts. As a researcher, you just need to keep asking yourself why, right? You can't take anything for granted. So you must be curious about everything in the world. Given that society is getting more complex, more uncertain, you need to work harder at finding things, at reporting them, at documenting them.
Mr. Shishira Rudrappa is the managing trustee at IDIA and has graduated from National Law School of India University and was a Thomas Bergenthal Scholar at George Washington University, where he completed his master's in law. Sir is also the director at Spire Capital and is one of the co-founders and directors of a legal news and news and intelligence company, Parent Bench. Sir was also the co-founder and director of Clutch Group, which was a legal outsourcing company. Presently, Sir is a member of the board of advisors of Cult Vriksh Fund, which is a Category 2 alternative investment fund. Sir has previously worked on the campaign of the Chief Minister of Karnataka, Mr. Siddaramaiah, and was appointed in the Chief Minister's office as Special Officer to the Chief Minister of Karnataka. We are very honored to have you, sir, and we would be pleased to hear some words from you. Over to you, sir.
Good morning to all the guests. Thank you, Director Khan and Professor Dhanya, for this invitation to speak on my good friend Shamnad and his impact on IP and legal education. I feel this symposium might run out of time if I start speaking on all the contributions of Professor Shamnad Bashir and a friend of students, Shamnad. I will still make a futile attempt to summarize his achievements in this short span. I never worked with Shamnad on his IP projects, but I also always spoke to a lot of scholars in this field. Do you know why a cancer care drug is sold at a fraction of cost in India? It is because of Shamnad and his legacy to IP. It's not just about the money alone. Shamnad managed to convince Indian courts and government about the importance of balance and also that there is a limitation to all forms of intellectual property. This, according to many, is unparalleled and has never been achieved in the world, something even the likes of Larry Lessig have failed in the US. Since I'm in a room full of IP experts and scholars, it's best for all of you to study his contribution to IP, copyright, and gauge his importance independently. Shamnad dedicated his life and for diversity and inclusion in legal education. In the late 80s and early 90s, late Dr. Madhav Menon started a revolution in legal education. Almost 20 years later, the 2.0 version of Dr. Menon's revolution was launched by Shamnad by founding IDIA. I was thankful to him for including me in this journey to build IDIA. Increasing diversity by increasing access was initially started to ensure we bring legal education to underprivileged kids. But slowly we realized that these underprivileged kids brought a different dimension of learning to these privileged kids who had no idea about it. It was Shamnad's vision that IDEA should go to villages, sensitize these micro communities to law and legal education, and then choose potential scholars from these micro communities who had the aptitude for learning the law. This was a hard task, mind you. Whenever we discuss impact of IDIA, we are measured in terms of the scholars that are in various law schools or scholars that have graduated. Till date, we have about 140 scholars who are in various parts of the world. But one story that always touches my mind is on August 8, 2019, when the news of Shamnad being no more reached more people. A young girl from Northeast called me. She was part of the first initial batch of scholars that Shamnad had picked to study the law. We trained her. She did not make it to any law schools, but using the training we provided her over a period of 2 years, especially in English, law, logical reasoning, it helped her to secure an admission and scholarship to another undergraduate program. She completed that and later that week was hired by BBC to work in their London office. So what did Shamnad's IDEA do? IDEA has sensitized more than 38,000 students over the last 10 years towards the study of law and making legal education more accessible. Shamnad never thought that IDEA belonged to him. He always felt that we were custodians of IDEA, and we worked towards a common goal that IDEA becomes irrelevant one day. Everyone we know builds an institution to grow in size, grow in numbers, grow in location. But here was a professor who was building an institution to such heights that the institution itself becomes redundant. And our law schools and institutions would display diversity and inclusion as part of his DNA. Everyone asks me, saying, why is Shamnath so revered and loved even after he's no more? I felt that it was because he was honest and personal with his students. He never would, he would mean when he asked, how are you? A phrase which we casually ask each other. Shamnath was not just a kind man, but a towering intellectual. But he did that in a way that he did not make the other person feel lesser about themselves. I always felt he achieved all of it because he genuinely cared about what he did. If he did not care, he would not have achieved it. With that note, I thank you all for listening to my brief and a limited facet of a man who should have lived a lot more years to have made legal education and society at large a happy place. Thank you.
Thank you so much, sir. Your words did help us in understanding how Shamnath sir was, even though we could not meet him in person. So thank you so much for that. Now, before we move on to the next speaker, I would like to welcome our special guest, Mr. Amit Datta. Sir is a partner at Sai Krishna and Associates and has been heading their telecom media and technology practice, as well as the policy development and reform practice. Sir has been an IP litigator who has a specialization in terms of copyright, trademark, and design litigation, and has been a trade and regulatory compliance over the past 20 years. Sir's specialization also run across technology, media, and entertainment sector. Sir deals with a lot of variety of issues on IPR, films, music, technology, e-waste, and more importantly, Sir has advised a lot of clients on terms of the policy developments relating to the personal data protection issues in India. In 2010, Amit Sir was invited to appear as an expert witness before the Parliamentary Standing Committee, which was reviewing the wide-ranging amendments to the Indian copyright law. More importantly, Sir is also a high-ranked individual across international ranking journals in relation to IP litigation and media and entertainment. We are very honored to have you, sir, and we would be pleased to hear from you. Over to you, sir.
Thank you, Ramdeep. A very warm good morning to all the panelists and the viewers and colleagues and friends watching this program. I think I'd like to thank Dr. Khan and Symbiosis particularly for remembering Shamnath, who's been a friend to so many people. Shamnath, who's been a mentor to so many people. And this is particularly poignant for me because this is probably the first time I've had an occasion to speak about Shamnath and his legacy publicly since he left us, since he passed away quite unexpectedly. Shamnath and I interviewed at our first jobs or retainers, as litigating lawyers prefer to call them, at Anand and Anand in October of 1999. And I vividly remember me, a student from an ex-former law student from Jabalpur, and Shamnath Bashir, a recognized student, a marked star on the rise from the National University in Bangalore, the celebrated NLIU from Bangalore. And I remember looking down at my CV, my resume, which was hard-pressed, even with double spacing, to fill one page, bereft of any achievements, bereft of any publications. And I looked to my right and I saw this rather young man. There was a difference of a few years, quite a few years between us, 5 or 6 years, 7 years, I think. And I saw his CV, which was at about 3 pages, with about 5 or 6 annexures, which were his articles. And the first thing I ever said to Shamnath was, "Did you have to come today for an interview?" Because I knew that with a candidate sitting like that, I might as well just pack up and go home. And he laughed, and we were friends since. And when I look back at what Shamnath did as an IP lawyer, as an IP academic, as a legal jurist, as somebody who gave so much to this world, I remember how Shamnath developed as a lawyer in the inception, I remember his keen sense of inquiry, and a remarkable facet about Shamnad Bashir was his ability, his innate, very natural instinct to push the envelope and to question the legal status quo. And by legal status quo, I mean our very often Commonwealth based training in legal traditions and legal jurisprudence, which we often feel unable to break out of, with the drifting wood that saves us from drowning in many court cases being comparative law approaches. We're looking to England, looking to New Zealand, Australia, and America for legal precedents. Shamnad Bashir largely eschewed that approach and was open to looking at approaches which were more Indian, which were more homegrown, and which suited India. And I think he stood out there. And I remember him vividly with his experiment with court litigation, which he thoroughly enjoyed and at the same time thoroughly hated, was with the case of Taj Television versus Rajan Mandal, which was the first John Doe order which Shamnath conceived, put together, and an injunction was granted. And you've seen over the years, in good ways and bad ways, how that injunction and the scope of that injunction against unidentified defendants has grown over a period of time. I vividly remember Shamnath calling me and speaking about his thesis, his PhD thesis, where he provocatively and very provocatively for IP circles on either side of the pharma industry, for instance, where he proposed an investment protection regime over and above patent protection and data exclusivity. And I predicted, I said, you're going to get tarred by the originator side, and you're going to get feathered by the generic pharma side. And that was precisely what happened. But I think, and I suspect, that Shamnath enjoyed it. He enjoyed it because without provocation, without looking at out-of-the-box solutions, we would never have path-breaking legal precedents. And then Shamnath's contribution, did not only stop there. I remember when I was working on the amendments to Copyright Acts for songwriters who, for decades since the Copyright Act came into effect, had never been recognized, had never been paid. And we were stuck within the Commonwealth, principle and tradition of legal ownership and assignments and the traditional Commonwealth approach to copyright law. Shamnath pushed us, and then pushed me particularly, to look at ideas that went beyond, and gave examples like the royalty suite, which is the author's resale right, for instance, as an example of how Commonwealth tradition has incorporated, for instance, civil law traditions. And then we came to the author's right to an equal share of royalty, which was enacted in 2012, and which now, years later, I would say is largely a success, because industries accepted it, users have accepted it, and virtually for the first time in history, artists are getting paid. I remember Shamnath's involvement in the 2012 amendments to the Copyright Act, even more particularly for his siding and helping physically challenged community in pushing the government for path-breaking amendments to the Copyright Act, which not only foreshadowed but were wider than our subsequent accession to the Marrakesh Treaty. And that was a passion that he discovered in his ability to build and his dream of a more inclusive society, which then spread to IDIA. And I can tell you that Shamnath wasn't shy of telling people to contribute to IDIA, particularly his friends. We would often get calls, we would get fired up by Shamnath and were told to contribute. And none of us, I think, dared to do anything other than contribute. I remember him for not only the fact that he wanted to be provocative where the law was concerned and think out of the box, but his innate sense of integrity and his courage for standing up, for instance, in challenging the IPAB provisions before the Madras High Court, which struck down various provisions of relating to the IPAB, which required the government then to reconstitute the IPAB. I remember him vividly talking about his intervention in the Novartis case as an academic. And we had long discussions about why the academic community was not more visible, like in America, in amicus briefs, and putting out middle of the road, dispassionate, articulated legal arguments to help the judiciary as friends of the court to reach better solutions or arrive at better judgments, more informed judgments, as opposed to only being guided by a for and against side. And I think the Novartis case is a singular standout example of how academics can contribute fruitfully and positively to the development of law in our country. All of this, kind of led me to believe that Shamnad, was anywhere and everywhere. In academics, in court cases, with IDIA, but that was the man. And what he left behind were overawed disciples, lifelong admirers, and people to some extent like me, who would try and achieve even 1/10 of what that man achieved as a young man, as a relatively young academic. I think I would count myself successful and lucky and privileged if I would achieve that, that little bit. Shamnad, I think, is going to be remembered for IDIA and his contribution to IP, but more so by his contribution to the fact that he left behind a principle and a belief that an inclusive society, a society that is more plural, is always going to be a better society, whether in intellectual property or in any other field. And IDIA will continue with Shishira and Nihas and other trustees, and the fact that a IDIA scholar just recently was awarded the gold medal is a singular example of the legacy of Professor Shamnad Bashir, my friend and brother to many. And I'd like to thank Symbiosis for inviting me to speak about Shamnad. It's been a privilege. Thank you.
Thank you so much, sir, for your kind and warm words. I do hope that as the next generation, we are able to touch upon the learnings of Shamnath, sir, and ensure that there is inclusivity of a higher level in the next 10 or 20 years. Thank you so much, sir, for your warm words. Now, I would again like to remind everyone that we have with us Nihas Bashir, sir, who is the partner at Wadia Gandhi and Company and is the brother of Shamnath, the late Shamnath Bashir, sir. I would like to thank Nihas, sir, on behalf of the Center for Intellectual Property Research and Advocacy, as well as Symbiosis Law School, Hyderabad, for allowing us the permission or giving for giving respects or paying our respects to the memory of Shamnath, sir. Thank you so much, sir, for being here as well. Now, before we move further, I would like to introduce the chief guest for today's occasion, Professor T.C. James. Professor T.C. James is the president at National Intellectual Property Organization, which is a non-profit intellectual property foundation. He's also a visiting fellow at Research and Information System for Developing Countries, which is a policy research institute where he is guiding research in terms of health policy and pharmaceuticals. Sir is also the member at the Speakers Research Initiative. Apart from this, Sir is a guest faculty at the Indian Law Institute and Indian Society of International Law, New Delhi. Currently, Sir is the member secretary of the Forum on Indian Traditional Medicine, which is set up by the Ministry of Ayush at RIS with the objective of contributing to pragmatic policy making in terms of traditional medicine. Sir's previous assignments also include him being the director of IPR in the Department of Industrial Policy and Promotion under the Government of India, him being the member of the Academic Council of the Shikhavati University, and him being the consultant in terms of IPR at the Federation of Indian Chambers and Commerce Industry, as well as the United Nations Industrial Development Organization. We are very honored to have you as our chief guest, sir. If you may please address the crowd further.
Thank you, Ravi. Good morning to all respected panelists and eminent resource persons and dear participants. I'm grateful to Professor Sarfaz Ahmad Khan, Director and other organizers for inviting me to this event. It was rather the persistence of Professor Dhanya that made my participation possible. I appreciate CIPRA for organizing this event in memory of Professor Shamnath Bashir, a very dear friend for a long time till his untimely demise. He was one who fought for maintaining the balance between private rights and public interest in intellectual property rights. I congratulate the department on the topic selected for deliberations, which is changing dynamics of intellectual property for development. I propose to focus on one of the issues which is currently drawing attention, that is the one relating to artificial intelligence. It's a topic on which academic discussions are taking place all over the world. The WIPO is also seized of the issue. In India, on the science and technology of artificial intelligence, much discussion is happening. Last week only, India organized a global virtual summit on responsible AI for social empowerment, which was addressed by the Honorable Prime Minister. In his address, the PM rightly said that collaboration between AI and humans can do wonders for planet Earth. Certainly, AI can do a lot in agriculture, education, healthcare, and many other fields. At the same time, artificial intelligence raises many issues. Some of them relate to ethics and some to law. The main thrust of my presentation is that IP law is a product of technology and economics. The emergence of new technological innovations during the proto-industrial revolution period from the 15th to the 16th centuries paved the way for patents and copyrights in various European countries. The first industrial revolution, propelled by water and steam power, during the 18th and 19th centuries, saw the fine-tuning of the national laws on IPRs, such as the Statute of Anne on copyright in 1709 in England. The second industrial revolution during the 19th and early 20th century, which used electric power to mass produce items, saw the emergence of international IP law. The Paris Convention on Industrial Property of 1883 and the Berne Convention for the Protection of Authors and Artists in 1886 were the main IP happenings of this time. The third industrial revolution during the second half of the 20th century, which employed electronics and information technology to automate production, saw the widening of the scope of IPRs to accommodate new technologies and their products. It almost culminated with IPRs becoming a part of international trade law through the TRIPS agreement in 1994 and also the two WIPO internet treaties. The digital revolution that is now giving way to a fusion of technologies leading to the artificial intelligence age, where machines have the possibility of becoming autonomous. The question before policymakers and law philosophers is whether the new revolution, which some economists term as the fourth industrial revolution, requires a new set of IPRs or whether modifications, the existing ones, can meet the challenges. The present international agreements actually have adapted existing legal regimes to the requirements of digital technology and digital economy to a great extent during the last century and early part of the century. From the IPR angle, the issues of AI fall generally under two areas. One, the new technological products and processes, and two, the works created by AI. They generate issues both in patents and copyrights. Patent issues relate to who is an inventor and what is inventiveness and non-obviousness, then infringement by artificial intelligence, etc. The TRIPS agreement has made it obligatory to grant patents for all inventions in all fields of technology if they are new, involve an inventive step, and are capable of industrial application. Thus, from an international law perspective, will it not be right to say that there is no bar in granting patents for an invention made by a machine if it satisfies the other three criteria? The follow-up issue on this is the identification of the inventor. Most national legislations on patents do not define inventor, perhaps under an assumption that only a human being can be an inventor. After all, IP legislations were conceived in an age before AI emerged. Can it be circumvented by declaring that the owner of the machine or the person who programmed it is the inventor? After all, but then human beings are also programmed in their genes. Complexity increases where artificial intelligence becomes more advanced and fully autonomous, and when it has the liberty to make its own decisions. There is also the issue of inventiveness. How will a patent examiner determine the non-obviousness of an AI-created invention? If it is made by a man-made machine, will it not be obvious? What about machines that may be capable of bettering itself? How can the examiner adopt the criterion, the invention not obvious to a person skilled in the art? Can a legal person fulfill this? All that one can say at this juncture is that all these issues are complex and full of uncertainty. Even without granting patent rights to artificial intelligence or its owner, there may be a need to redefine person ordinarily skilled in the art to include a person equipped with artificial intelligence, since such a person's capabilities are much higher than the ordinary person. But that will be stretching the meaning of ordinarily too much, since most people may not be having an AI equipped machine with them. Will it create a new division of haves and have nots? Then there is also the liability question. If AI infringes another person's patent, who is liable if it is not treated only as a tool in the hands of the owner? With the changing landscape of the technological developments, most AIs are now capable of infringing other patented claims. The arguments for and against granting patents to AI inventions are not always based purely on legal logic, but on other general justifications. Some scholars are of the view that granting patent rights to AI generated inventions would act as a catalyst for new and advanced innovations, which would be difficult to achieve through human inventiveness solely. Equally convincing arguments are made by opponents, but again, not from a legal point. They say that granting patent protection to AI-generated inventions will raise the cost of R&D, increase the monopolies, thereby impeding innovation. These are all relevant issues, and one cannot wish them away, saying that they do not belong to the realm of law. In fact, in IPRs, often decisions were made on the basis of economic angles, such as others making profit out of one's invention or work. That is how these rights came out as negative rights, that is, preventing a third party from using the invention or the work. One cannot also take solace under a belief that the scenario may be one of science fiction that may take at least many decades to happen. Robots are already being given citizenships. Saudi Arabia granted citizenship to Sophia, a humanoid robot, in 2017. That same year, Tokyo granted official residence status to a chat box named Shibuya Mira, programmed to be a 7-year-old boy. What will happen if Sophia applies for a patent either in Saudi Arabia or in another country? Considering the national treatment obligation, can another country deny the patent on the ground that it's a machine citizen? These are all questions for which we do not have ready answer. The copyright questions relate mostly to authorship and originality and, of course, liability for infringement. There are also issues being raised about the appropriate IP for the software, which is what IP is. Although this question was settled in the TRIPS agreement, uh, the matter was reopened in the US by various court judgments. And even after Alice Corporation versus CLS Bank judgment, the matter is still there, mainly because of the parties involved, that is, multinational companies. In India, we followed the track of computer programs per se not eligible, but two recent judgments of Delhi High Court raised some issues. I am referring to the 2014 judgment in Ericsson versus Intex and Farid Alani versus Union of India in 2019, in which the court reintroduced the technical effect or a technical contribution if it is patentable to the computer program as a patentability criteria. This trend is because patent is a stronger monopoly than copyright and prevents independent development of a similar or identical program, which is permissible under copyright, and big corporations are arguing for that. The limited purpose in referring to these developments is to show that economic interests play a decisive role in shaping the law. Now, leaves a lot of issues, but I'll refer to one case how these things can happen if it is not big corporations. I am referring to the famous monkey selfie case of Naruto versus Latter, in which the US District Court took the view that neither the monkey who actually clicked the photograph nor the person whose machine it used and who made the arrangements has copyright, on the main ground that the animal cannot stand in the court of law. Now, the pro-copyright law argues that copyright and patents are to encourage innovations and creative works, and denying IP rights to products and works will disincentivize investments in technology. Some country laws have therefore made some provisions to meet this challenge, including the computer program definitions in the CDPR in UK and even in India. Now, this issue came up in 2007 in UK in the Nova Productions versus Masuma Games case. It was a case regarding electronic pool games in which the court observed that the author is the programmer who devised the appearance of the hall and the design of it. But still, the issues of originality, copyright, etc. loom large. One way is to adopt the doctrine of nearest proximity that would give many a time the producer or the programmer the rights, as it has been done in the Indian copyright law as well as in the UK law. The other thing is about the doctrine of works for hire, which we are using as the work in the course of employment under a contract of service. These are all some solutions, but not the total solution. What is to be recognized is that IPRs, be they patents or copyrights or trademarks or any of the other ones, are basically economic rights to safeguard investment in various industries. Inventors and creative authors are not that much incentivized or motivated by the economic gains as their own internal urge to find a solution to a scientific problem or to give expression to their creativity. If that were not so, we would not have had those great scientific inventions in the pre-patent era and the great literary and artistic works in the pre-copyright times. Thus, true, as the Universal Declaration of Human Rights says, everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. In this age, where everything is commercialized, authors and inventors should be able to get rewards for their creativity, and people who invest in making their works accessible to the public should be able to protect their investment and the fair earnings from that. To that extent, IPRs are investment protection rights based on the philosophical fiction of protection of intellectual property. But AI has not yet reached that stage, and looking to the future, one must remember what Stephen Hawking warned, that autonomy of artificial intelligence can diminish the worth of human being. I conclude with my favorite author, Shakespeare made Hamlet said, "There are more things in heaven and earth, Horatio, than are dreamt of in your philosophy." There are more things in heaven and earth, Horatio, than are dreamt of in your philosophy. Thank you all.
Thank you so much, sir, for providing us with an interface between intellectual property and artificial intelligence. This speech that you gave is something that will help a lot of us in understanding the nuances of cyber law and IPR. So now, when we move to the guest of honor, Dr. Suryamani Tripathi. Dr. Suryamani Tripathi is the legal counsel and global legal head at the International Crops Research Institute for the Semi-Arid Tropics, Hyderabad. He is involved in the overall management of legal and regulatory issues related to operations and research of ICRISAT in terms of the legislative advocacy and statutory compliance. Sir is also an international lawyer, registered Indian attorney, and a registered technology transfer professional. Sir was instrumental in establishment and sustainable operations of Intellectual Property Facilitation Cell and Viper's Technology Innovation Support Center at AIP ICRISAT. Sir has been awarded his law degree from the Indian Institute of Technology, IIT Kharagpur, with his Microsoft IPR Scholarship Award. Sir also holds a PhD degree in plant science with CSIR Fellowship, an international master's with the Fellowship of the United Nations Industrial Development Organization and the Government of Italy. Apart from this, Sir is also the recipient of Associate Fellowship, the Center of International Sustainable Development Law, Canada, and the Scroll of Honor by the International Council of Jews. While Sir focuses on IPR commercialization, he has also been extensively working in the field of patents, technology commercialization, and has contributed towards various national and international forums. We are very honored to have you as our guest of honor, sir, and we would be pleased to hear some words from you. Over to you, sir.
Good morning to all distinguished guests and speakers of this panel and other participants, other presenters. I'm very thankful and grateful to Professor Khan and Symbiosis Law School for inviting me, giving an opportunity to share my experience. Before going to the discussion points, I would like to also say some words or few words about Professor Samnath Bashir. I had a brief interaction with him, I think 19 years ago when he was at NUJS. At that point, I was working on a draft legislation that was from the session of public-private, public research. We can say the Indian version of Bedol Act. And during that point of time, I came to know that he is working a lot on public-related issues, especially in IP and public laws. So I wrote a couple of emails to him. Then he invited me to discuss at the NUJS. I went and met him. I was very much surprised. A person, generally we feel that lawyers, they deal only in law and they don't consider the other parts of the thing. But when I started interaction with him, because I was having a science background, he started asking a lot of question about the science, how the plant works, and what are the technology in genomes or biotechnology, what are the various aspects and that. And what are the scientific logic behind or scientific principles behind when we deal with the life sciences. So at that point of time, I realized that this is a person who is not dealing only with law. He's capturing the information from the all relevant domain and then trying to convince the court, the policymakers, how to deal with the law, making a balance between the IP laws or the public at interest. So that was interaction. But after that, I continuously started reading his articles and his whatever advisory he has given to the policymakers and the courts. So it was a very shocking news for me. I was very much surprised. First, I didn't believe that this has happened. But anyway, somebody said that it was the God wish. So it is a big onus on us, being a IP professional, practitioner, or the faculty members. In all our capacity, we have to encourage or we have to adopt that model, what has been proposed by Professor Samna Basi. That means we have to inquire, question each and every aspect, whether it's a science or the law, whether it's a part of the judgment or it's a part of the policy, and then give our opinion, our different way of thinking, different way of processing, and give our opinion. So with these words, I would request all the law schools, students, faculty members, that this is if in true sense, if you want to give anything or any importance to Professor Samnath Bashir, we have to adopt his learning or way of thinking process. We may not be fully successful, but if a part of thing we can adopt, that will be very helpful, giving importance to his contribution to the IP system. And because I interact with the various jurisdictions, especially African and South American jurisdiction, Indian laws, Indian court judgments, they are being interpreted, cited, and given due weightage in those jurisdictions also. So it is again a big onus on us that rather than fully relying on the Western court jurisdictions or their orders or laws, we should develop our own model. We should develop our own jurisprudence, especially in terms of IP and other technology law related field. Like example, I can say we have our own different model for a plant variety protection, which is well known, which is well adopted, and it is being referred at a various jurisdictions. So in similar model, we should also think from a different perspective and give a new model to the world. So world is also looking from us, how the India is doing, how the Indian courts are interpreting, how the Indian lawyers are interacting in the courts. Now coming to the point of this symposium, I think this symposium is relevant and a good forum where I can communicate my message, because I represent the international public research body. So at the research, doing research, whenever we feel any problem, the problem is two things. One is the regulatory aspect, and another thing is the IP. So issues related to IP generally happens when we deal about the technology transfer, technology use, or technology commercialization. So what is my observation? That we are dealing a lot, we are working a lot on IP protection and IP facilitation, IP related laws. But unless until we also focus on tech commercialization, technology transfer, or models related to tech transfer, then the whole objective, the economic model, the business model of the IP will not be successful. So for that purpose, because I represent the research organization, I would request the participant to discuss a lot about, even we are discussing about the IP law, the principle, we should also discuss about the business aspect. That means tech transfer of models or IP commercialization activities. Like Professor James has very rightly mentioned, the artificial intelligence. So whatever the point he has raised already, these points have started coming to the courts because there was a one case of the Professor Stephen. He has filed one patent application citing the artificial intelligence machine as innovator, and USPTO, then UKPTO, EPO, they denied, and the matter has gone to the court. And in September, I think last week of September, we received an order from the UK High Court, and there also they denied the inventorship. But in that, if you read the judgment, many new aspects have been discussed. And I would say that because of this patent application only, the EPO and the USPTO has asked for a public opinion on this. So see, the one patent application, one invention related to IP has created a sensitization to the policymakers, and now they are asking for a public opinion. So very soon we will see that something will come out in this area also. So this is the right time that Indian scholars would also work in that, give some writing or some scholarly publications, some opinion. Like if you see the IP jurisprudence and the law, they evolve with technologies. Like Chakravarti case in the biotechnology, or take example for a non-conventional trademark. All these things were not originally contained in the law or the principles or the rules and regulations. But over a period of time, when the lawyers started pushing, started convincing, or to the policymakers and the courts, these principles evolved. Now you can see I'm talking about the biotechnology. Take for another example, last week we have heard about the patent application in chemical. The Nobel Prize has been given to two ladies, innovator, Emmanuel and Jeffrey. So that particular patent, that particular technology is related to CRISPR-Cas9 gene, and this CRISPR-Cas9 gene is a platform technology. The wider application to all domains, especially in life sciences, we see a lot of usage in medical science, cancer, AIDS-related diseases, and at ICRISAT, we are also using this technology for genomics and plant-related innovations in crop breeding or biotechnology plant creation. So you see, within 10 years of time, because technology evolved in last 10 years only. So within 10 years of time, the pace of technology is very fast, and there are so many IP disputes. If somebody is interested, they can go and check on the Google. They will find there are so many IP disputes going on in Europe and US on this particular technology only. But the importance of this technology is not diluted. Now we see that CRISPR-Cas9 technology is widely used in various biomedical and the life sciences, plant sciences domain. So what I'm trying to emphasize here, during this discussion, during such kind of gathering where the scholars are coming and presenting, we should analyze the ongoing evolution of the technology also and connect with the law and suggest some models some policy guidelines, some documentation, or some recommendation to the government, courts, and the policy makers so that our laws and our process procedures should be up to date. And these process procedures, these legal standards, judgment should be referred to the various other jurisdictions, and India should come into the forefront in the legal principle also. So in many fronts, we are ahead, but still, I feel that on the legal jurisprudence or the citing of the Indian cases, we cite the European or American cases. That is not happening. That the Indian cases are cited at the various locations. Professor James has, I think, touched the key point. Whatever we do, we should also keep in mind the technology, the pace of technology, how it is moving, and what are the challenges. To add to the Professor James, I would like to say that in the digital era, the how we are dealing with commercial transaction over online and the dealing with the territorial nature of the IP, now it is also in question because we are taking the item from abroad or we are selling any product abroad. How the trademark infringement or the patent infringement will be evaluated, or how the courts will take a cause of that. So again, this is another area where the question of the territorial jurisdiction of the IP laws, especially in a digital domain, we need to discuss. And I am very much sure that next 5 years, you will see the WTO or the international bodies or WIPO, definitely they will come up with the new models, new principles in dealing with the international business or the international transactions. So what I would say that we have seen various types of IP discussed in this forum at a various other forum, but we restrict ourselves only to the few IPs like trademark, copyright, patents. We generally don't discuss with other forms of IPR. Like in last 1 or 2 years, I have seen some work in the field of geographical indication. Before that, nothing was happening in the field of geographical indication. And that is the reason that recently we have seen the amendments in the rule of the geographical indication for authorized users. So that means still a lot of work needs to be done in the field of geographical indication. Similarly, in the plant variety protection, because I deal with that particular subject matter, again, I would emphasize the lawyers should also come into that. Lawyers are not giving too much attention to the plant variety. Plant variety is also a different form of IPR, but very, very important for Indians or developing countries because we have developed our own law, which is not a copy paste of other country, other jurisdiction law. So we have to popularize this law so that other countries, other nations would also adopt, and we can create an international jurisprudence in the IP laws. So with this remark, I would thank again to the organizers, and I have seen the agenda points of the meeting. The topics are very, very relevant, very important. And I'm hopeful that after this topic, after the presentation, some recommendation will be given to the government and the judges, and the outcome of this symposium will be referred at the various forum. Thank you very much.
Thank you so much, sir, for those kind words. We do hope that we are able to give these recommendations out to the judicial committees as well. And we are thankful for you to be being a part of this national symposium. Now, moving further, I would like to introduce our special guest, Mr. Jatin Trivedi, who is the senior partner of YJ Trivedi and Company. Sir is one of the founding members of the Gujarat Innovation Society and the chairman of the legal subcommittee of the Federation of Indian Chambers of Commerce and Industry under the Gujarat State Council. He has also served as the IP advisor to the Gujarat Electronic and Software Industries Association, the Indus Entrepreneurs, the Gujarat University Startup and Entrepreneurship Council, the Research Park Advisory Committee of Gujarat University, and the Khadi and Village Industries Commission. Apart from this, Sir has authored a book titled IPR Law in Practice and has written 2 books in succession, which are titled This Handbook Will Change the Face of Your Startup and The Handbook on Intellectual Property Rights for Startups and Entrepreneurs. These two books are a part of a comprehensive series that provides a business entrance in the 21st century everything that they need to know about intellectual property. Furthermore, Sir is also the national expert at the IP Facilitation Forum of European Business and Technology Center, the regional consultant on the roster of the world's supreme organization, WIPO. And WIPO has bestowed Sir with the privilege and responsibility of providing technical assistance in specifically to Sri Lanka, where Sir has played an instrumental role in ensuring the drafting of the Trademark Act and facilitated them in acceding to the Madrid Protocol. Once again, sir, I would like to welcome you on behalf of Team CIPRA and Symbiosis Law School Hyderabad and would ask you to kindly share a few words. Over to you, sir.
Thank you, Navneet. Am I audible?
Yes, sir.
All right. Thank you to Dr. Khan and his team. And thank you very much, Symbiosis, for inviting me and sharing my thoughts on the changing the dynamics of intellectual property rights in India. My special thanks to the Symbiosis team because this is such an opportunity where the event has been organized in the memory of my dear friend Shamnath Bashir. He was not just a friend, but he was a truly inspiring personality and in the field of intellectual property. And the seminar of such as this would have immensely pleasured him, that's for sure. I extend my heartfelt gratitude to his family and his brother who is on the line. And thank you very much for allowing Symbiosis and giving us the opportunity to remember him, as his contribution was immensely in the field of intellectual property. And I'm sure the students who is listening, they will have a lot many things to take away from and learn from his life and also take away from his sessions as well. I'm sure many of us have talked about the Dr. Shamnath, but he's the man who we cannot forget ever. And his contribution is every day we remember. And even the one incident which I will share, since many of you have discussed about Shamnath, I have been unfortunate, I would say, that on the 2nd of September, if I rightly remember the day, 2nd of September, he was to be in Ahmedabad and he was to be awarded by the hands of, in presence of the law minister of the state, as an inspirational icon of the year for 2019. Being an organizer of that IP festival, which took place in 2019, I invited him as a guest and to share his thoughts with the industry, and later the Ministry of State have decided to honor him with the inspirational icon in 2019. Unfortunately, on the 31st, the day before, he messaged me that he's unwell and he's not able to travel. And so I have to convey the CEO of the organizers that he will not be able to travel. But I still keep every memory in my WhatsApp that he dropped, and I still remember those words which I wrote to him, is saying that I will still look forward for you to come at the last moment and at least take this honor which the state is offering. But still, I would prefer not to speak much about him because I get emotionally involved into that talk. Since the Institute has invited me to share my thoughts on the changing of dynamics in intellectual property field. Friends, intellectual property has witnessed tremendous growth and expansion in past 2 decades. Not only has its awareness is increased, but it has also entered in unconventional field, which we could not have thought around 15, 20 years back. This idea can be derived from the most basic fundamental examples of the computer, which once occupied the whole room or the desk and has now come on our palm or maybe on the fingertips we can operate. the AI is not confined to, as many of the speakers have talked about, the AI. AI is no more confined to the labs or the business places, but has traveled to our home in form of Alexa, and now it's in our palm or the hands in form of a Siri. Similarly, the availability of your favorite international brands in nearest mall, or a song of your favorite international artist available in India, also revolve in and around the intellectual property. Moreover, the knowledge of Ayurveda that has helped us so much in this time of a pandemic is also IP at a large. IP has impacted and changed our lives more than we can measure. That's I can say so. And it is an ongoing process, helping at multiple level, ranging from an individual life to industry and nation as a whole. Obviously, the academia situations has changed due to the intellectual property. The boundaries of IP are continuously broadening with the new fit achieved each day and every moment. Government also all over the world are now looking to boost their economy by creating an environment conducive for intellectual property development and protection. And that's what I've heard when I was part of the WIPO delegations to Sri Lanka. Our Prime Minister has time and again has stressed on the innovations and initiated programs like Make in India, Vocal for Local. Business entities and companies and major corporates have also realized the potential of intellectual property and its power to contribute into the success of the business houses. IPR gives the companies, small or big, a wide range of tools to help them derive their success and take it to the peak, right? The perk doesn't end here. If you ever get confused in the brand design or a type of an article as simple as a water bottle, right? As simple as a water bottle to buy, thank it to the IP that benefits the consumers and the society through a continuous supply of innovative and competitive products and services. I would say that it is not just a changing dynamic of the intellectual property, but is the innovation and intellectual property that are changing the dynamics of the development as a whole. A successful entity today necessarily needs to have the intangible assets in form of intellectual property. Allow me to just refer the few points how the intellectual property working on a different level and resulting into the development when what is the nexus between the two. With respect to the economical development, IP is promoting the FDI and the technology transfer is taking place, and that we have been witnessing since last a decade and a half. It has been observed that the sector that will rely on intellectual property represent a significant part of development and developing countries as a whole. Strong IPR protection has been promoting innovations and helping in dissemination of knowledge. The rapidly development technology is the result of intellectual property rights. With respect to when we talk about the small and medium enterprises, those who have more intellectual property as an assets have reported the higher growth, and we have witnessed that again in the our GDP contribution as well. With respect to the needs of public at large, intellectual property only gives birth to healthy competitions, but also address the needs of modern societies such as clean energy or a digital economy, currently what we all are enjoying and looking forward for the more development of those lines. It would not be exaggerated to say that innovations and intellectual property today has become a successful mantra. When I have been counseled by the several clients, and so I'm a bit familiar that the people acknowledge and confirms that the intellectual property has heavily contributed in the success or the growth of the industry. I was referring to one of the PwC report, and it was it was referred in that it is estimated in a decade or so, as much as 90% of the value of the world's top 2,000 enterprises will consist of intellectual property. So we can realize that what is the worth of it. And such changing dynamics would require use to prepare the change or laws, our laws, and whenever the required, it can be addressed by the industry or the legislature as well. I take pride in saying that the India has been advanced in both creating the intellectual property and protecting the intellectual property as well. IP to us is not new, but can be found in our most ancient text. Recently, if you've heard, the Ayurveda today is recognized as a comprehensive system of medicine as well. If we go to and refer the Aryabhat, had proved the existence of solar system on those days, many centuries before the modern science knew it. The Ramayana and Mahabharata are the world's renowned piece of literature. From painting of Ajanta and Ellora to architect of the Taj Mahal and known folklore or the songs of the tribes. India has abundance of intellectual property, and not only this, the intellectual have always been protected and rewarded in a royal court of king as well. Therefore, I believe that the India was quick to grasp the modern concept of intellectual property as the concept emerged towards the end of 19th century. The concept of copyright was introduced in India as long as ago 1847, when the first Indian Copyright Act was enacted. Subsequently, in 1914, the British Copyright Act came of 1911 or so, was made applicable to India. Around the same time, the Patent Act and the Design Act were also enacted. India joined the Berne Union as early as 1928. So our commitment to support the culture and creativity and innovation was by formulation of the Copyright Act 1957. The very fact that the India needed only a minor amendment in its copyright, and that too regards to the period of protection of the performer's right to fulfill the obligation under the TRIPS agreement. That clearly shows that the advancement of Indian R laws. So technological innovations pose new challenges to the enforcement of intellectual property right. More specifically, when I'm a practicing lawyer, I realize so. To ensure the protection, we have been amending the IP Act periodically. To make them modern and up to date, we have been keeping up with the digitalizations by enabling the online filing currently, and now even the virtual hearing as well, and virtual conferencing. Adding, we all are working to enforcement of such rights. The development can also be seen in the judicial end, and without referring much on that, but I would just say that the ones the Honorable Court have time and again have stressed, but the ones the our Justice sometime in 2005, our Chief Justice of India, Justice Y.K. Sabharwal ji, said, and here I quote, every attempt will make to put the nature of the litigation, that is an IPR cases, to put it on the fast track. I would also refer at this juncture Justice Kajus, who in case of Bajaj Auto Limited versus TVS Motors Limited, that is civil application 6309 of 2009 of the Supreme Court of India, said, and here I quote, that matter relating to the trademark, copyright and patent, the provision of Order 17 Rule 1 Sub Rule 2 CPC should be strictly complied with by all the courts, and hearing of the suits, such matters should proceed on day-to-day basis, and the final judgment should be given normally within 4 months from the date of filing of the suit. So judicial authorities are also recognizing the unconventional trademark, such as red shoe and shape of the building. Recently, I'm sure many of you must be aware that the Taj Mahal has been protected as a trademark, and they will get the further protection with the rule of law as well. However, there is always a scope of improvement. in India, and India needs to allocate more funds to concentrate at the development and fostering the culture of innovation and intellectual property as well. We still have a long way to go in creating the perfect system that effectively protect the intellectual property innovations and simultaneously encourage the innovations and curb the infringement in digital era, that is more specifically recently. The piracy has always blown a big dent on the media and entertainment industry and are required to be dealt with the more effective manner. Similarly, the sale of counterfeit goods have been major issues and active steps are required to be taken to control the same. It is also important to note that the irrespective of the effectiveness of the law put in place, the society at large will only be benefited by the awareness of the intellectual property and the importance of the same. The understanding of the importance of the intellectual property protection generates the respect for the intellectual property, which results the willing compliance and prerequisites of the effective enforcement in the field of involving daily applications to everyone's life. This has spatial relevance to today's India. We are largest producer of the feature film in the world, and sale volume wise, our music industry the second to the US in the world. The strength of our software industry is known to one and all, been much in talk. Our pharma industry is growing with a huge investment in intellectual property resources and development, and a number of patents to its credit, more specifically the pharma and the technology industry. Our university and research, more the R&D department within the university's campus, the university and research institutes have also started acquiring the patents on their innovations. And thanks to the current government, who's promoting and compelling or designing the modules by which the university and research institutes are get motivated. It is therefore vital for India to concentrate and strengthening of academic fraternity education institutes as well. Before I end here, I would, since I believe that many of the students are on the other side, to the students who is attending the seminar, I would say that IP has opened a whole new spectrum of opportunity today. It offers career that is challenging and emerging as well. Intellectual property laws are comparatively new when we compares the other laws exist in the country to the world, and needs a lot of working. That is where the opportunities popped up for the upcoming lawyers like you. I would suggest to those who are interested that the climb on the bandwagon with the hesitation, without hesitation rather, and you would not regret for sure the promising career that intellectual property offers. With these words, I once again thanks to the organizer for giving me this platform and sharing my thoughts in the field of intellectual property. I believe I've not taken much of time, and thank you very much for the hearing. Over to you now, Nit.
Thank you so much, sir. So every point that you've mentioned in terms of expanding our horizon in terms of researching on intellectual property are something that the Center for Intellectual Property Research and Advocacy and Symbiosis Law School Hyderabad will take up in the future. And we are very thankful for imparting those words to us, and we will ensure that these words are implemented upon. I would like to thank you once again for giving us your time. Now, while we move to the presidential address, I would like to welcome our guest, Dr. G.V. Reddy. Dr. G.V. Reddy has secured his LLB and LLM in Constitutional Law from Osmania University and has done his PG in Diploma in Human Rights from the University of Hyderabad. And he has done his PhD in Law from Osmania University in 1999. And the topic of his PhD was Supreme Court and Judicial Activism. Sir has been involved with Symbiosis Law School Hyderabad for a very long time, and he has ensured that every activity that we've taken up in terms of any domain that we choose. He has been a very strong pillar of support all throughout. Sir has practiced in the High Court of Andhra Pradesh for about 7 years in the chamber of late senior advocate Shri S.R. Ashok before he joined the Faculty of Law, Osmania University. Apart from this, Sir has authored 20 well-received books on women and law, intellectual property rights law, copyright law, and two of his books, namely Women and Law and Judicial Activism in India, have been reviewed favorably in the book review section of The Hindu, which was done by Justice V.R. Krishna Iyer. Sir has also worked as the principal of University College of Law. He has worked as the head of Department of Law and Dean of Faculty of Law at Osmania University. He was the member of the General Council of Nalsa University of Law for the period of 2011 and to 2014. Then he worked as the Andhra Pradesh State Consumer Protection Council from the period of 2010 to 2013, and has worked as the Telangana State Legal Service Authorities and the Hyderabad District Legal Service Authorities as well. Now, at present, Sir is a member of the Academic Council of Nalsa University. He's the chairman of the Bioethics Community on CDFT, Hyderabad, as well as the Dean and Faculty of Law of Telangana, Sadbhavna Universities. We are really thankful and we are honored to have Sir, and we would like to hear a few words from you, Sir. Over to you, Sir.
Yeah. Thank you. I think I'm audible. Professor Sarfraz Ahmed Khan, Professor Dhanya, Professor Navneet, and all the dignitaries who are present in the inaugural session, and dear colleagues and participants. At the outset, I pay tributes to the doyen of IP research in India, Mr. Shamnath Bashir, and probably IPR and late Shamnath Bashir had become synonymous over a period of time. And I think it's a befitting tribute to him to organize this National Symposium on Intellectual Property Rights. And I'm happy that the topics which have been chosen for presentation and discussion are of contemporary relevance. And probably we have moved away from the traditional discourse on intellectual property rights to the discourse on the non-conventional and emerging forms of intellectual property rights. And 21st century, which is, in fact, witnessing a knowledge revolution and emergence of more and more knowledge industries. And one of the previous speakers has rightly mentioned that some of the top industries or firms in the world today, in fact, their assets, 90% of their assets consist of intellectual property creations. We always, make it a point to highlight the economic value of the Apple brand as consisting of nearly 60 to 70% of the value of its total assets. Be that as it may, what we have seen in recent times has been a shift towards a more practical approach to the intellectual property rights, at least in India. The West and other countries, certainly they are well ahead of us. One example is today we are positively thinking about patenting of computer programs. As decided by the Delhi High Court recently, within the last 1 year, we have seen that the computer related invention guidelines, probably, though they had a faulty start, they will have a salutary effect in ensuring that the patents are granted for computer programs, of course, may be subject to all those guidelines like the satisfaction of all the eligibility conditions for grant of patent, provided there is a machine and transformation test, etc. So in coming years, I think this is one area where we will be seeing more and more computer related inventions and business methods being patented. And I think the research also will be focusing more on this. No more dependence only on Binsky versus Capos 2010 US Supreme Court and all. This is one aspect. The second one is that, in fact, we are seeing more and more emerging inventions in the field of intellectual property, which are patented from rural areas. In Telangana state, we have a live example of one Mr. Mallesham, who has been awarded Padma Shri, 2 years back, coming out with a machine called Lakshmi's Asu machine, which is useful for thousands of weavers who use tie and dye technology in weaving handloom textiles. And this is rated as one of the most promising rural inventions made recently by the Forbes. This is another important aspect. More and more rural inventions. And if we look at the National Intellectual Property Policy of 2016, even though the focus has been there on greater IPR education, what is missing is that the IPRs are not reaching the nook and corner of India. This is one problem. Practically, we may speak about many things, but at the same time, many of the original creators of intellectual property are left in a lurch. I think greater awareness levels will definitely help them in prospering themselves and also in contributing to the economic growth of the country. Then another important point which I wanted to highlight is about the lack of an intellectual property policy or vision for many of the, if not for the research institutions, because they already have one, but most of the universities and higher education institutions. This is one important area. And there is no, enactment like Bay-Dole Act in India. We are expecting one such act very soon. Similarly, a law to protect the trade secrets also, I think it is also in pipeline. But having a proper and effective intellectual property policy for these higher education and research institutions will certainly help us in, in fact, forging ahead. Then another important issue probably which can be discussed is the desirability or otherwise of the second tier patent system in India. I'm talking about the utility patents or utility models. And probably, since it is left to the individual members of the WTO, Government of India also can think about at least the utility model system at the indigenous level or municipal level. Then another important aspect is about artificial intelligence. From the last few minutes, I could gather that a lot has been spoken about the artificial intelligence. Issues are like, whether artificial intelligence is an entity in itself capable of claiming legal rights and obligations, or it is an instrument. This is one important issue. And here we come across number of instances, and we find that many of the, in fact, leading countries are developed countries. For example, China and US, they are now leading research in the field of AI. In fact, applied as well as more fundamental research. Similarly, they are challenged only by two other countries. One is by Japan, the other one is Republic of Korea. And we find that number of, applications on artificial intelligence have been increasing. And probably it is the time to recollect that the artificial intelligence, no doubt, is going to be an entity in future, if not today, because we require a paradigm shift in the basic jurisprudence itself. But at the same time, kindly recollect the 1996 and 97 episodes of the chess battle between the IBM created chess playing AI based computer Deep Blue and Gary Kasparov. Gary Kasparov, though won in 1996, had to lose to Blue Deep, not because of Blue Deep's original intelligence, I believe. Somebody said that it was because of the role played by another grandmaster, Joel Benjamin, who developed, and his team who developed this Deep Blue. So today we have number of, in fact, patents applications filed based on artificial intelligence. And probably machine learning is representing 89% of the patent families. Since India is very strong in the field of information technology. Certainly, this is one of the upcoming areas to look for. And of course, in fact, in jurisprudence, we discuss about whether machines can own property, animals can own property, and you know very well, like take the case of the Indonesian chimpanzees case, the monkey selfie case, ultimately which ended up in one of the district courts in America, where monkey selfie was held not to be capable of being copyrighted in respect of the chimpanzee which took the selfie. I'm talking about David Slater, the wildlife photographer from Great Britain, who made a lot of money by selling monkey selfies. That is one. Then we also have South African experience of a piglet. A piglet, in fact, trying to paint beautiful pictures. I don't know how, but somehow even Swiss Airlines also got a chance to purchase one of its paintings. This is another important issue. Chatbot patents now, in fact, they are being granted. The IBM was one of the patentees with regard to chatbot patent granted in 2016. It was a computer implemented method for conducting an automated conversation with a correspondent. Then there are many other cases. And, one of the speakers mentioned about Apple and Siri and Alexa. Here in 2012, there is a very interesting development that took place in Shanghai. Shanghai Network Technology Company Limited initiated a patent infringement lawsuit before a Shanghai First Intermediate Court. What they say is that Apple Siri has infringed its patent called a chat robo system, Zio I Robo. And as a countermeasure, Apple requested the Chinese Patent Re-examination Board to invalidate Xiao I Robo patent. So these are the battles. We can't expect only the battles between Samsung and Apple or Huawei, etc. Now we are going to, probably focus more on these important issues. Then about patenting of computer programs, I mentioned about Farid Alani's case decided by Delhi High Court, and we are fortunate to have such a judge with a lot of IPR expertise, Justice Pratibha Singh, who must be credited with opening of the vistas for patenting computer-related inventions. So we are going to have more and more computer knowledge-based industries emerging in the coming years, and probably mere theoretical knowledge is not going to help. The researchers have to work with the technocrats, because ultimately IPRs are going to be a fusion between the technology and law, as always. And probably this particular instance is going to occupy a more important position in the coming years. And I mentioned about the various other aspects, like we are talking about use of, in fact, artificial intelligence, even in medical technology, even in medical diagnostics. This is another important approach. And I had a look at the various topics which are taken up or which are divided between different sessions. And I'm very happy that the canvas has been spread very wide by the Center for Intellectual Property Rights of Symbiosis Law School, Hyderabad. And correct tone has been set, and it's a wonderful initiative. I sincerely hope that and wish this national symposium becomes a chart buster, and it, as pointed out by one of the previous speakers, it will lead to making of number of suggestions, policy, or maybe in the procedures, maybe in fact bringing out reforms in the intellectual property rights, education, advocacy, and also practice. With these few words, I thank the director of Symbiosis Law School, Dr. Sarfraz Ahmed Khan, and Dr. Danya, and other eminent dignitaries in the in session, and others for giving me this wonderful opportunity. Thank you very much.
Thank you so much, sir, for your kind words. Thank you for being a support for Symbiosis Law School Hyderabad in all the endeavors that we've gone for. Before we end the inaugural session, I would like to request our faculty in charge, Dhanya ma'am, to kindly give the vote of thanks. Ma'am, please.
Thank you, Navneet. Am I audible?
Yes, ma'am.
Honorable guests, esteemed faculty members, presenters, and my dear students. Today is a big day for the Center for Intellectual Property Research and Advocacy and Symbiosis Law School Hyderabad. On behalf of Symbiosis Law School Hyderabad and CIPRA, I express my heartfelt thanks to our chief guest, Professor T.C. James, for accepting our invitation and joining us today for this inaugural session. Thank you for helping us in understanding the nuances of artificial intelligence and IPR. Thank you, sir. I also express my gratitude to Dr. Suryamani Tripathi for accepting the invitation and also emphasizing the relationship between technology and IPR and highlighting the honors of Indian legal framework and how the other developing countries are looking for us, especially in the field of IPR. Thank you, sir. I also take this opportunity to thank Mr. Jadin Trivedi, Senior Partner, for accepting our invitation and also giving a practical dimension to the topic of today's discussion and also emphasizing about the innovation and development and how the IP can come and give contributions in the innovation and development aspect. Thank you, sir. I also thank Professor G.B. Reddy, sir, for accepting the innovation in spite of his busy schedule and joining for the inauguration session. Thank you, sir, for emphasizing on the various changing aspects of IPR which need much attention at this point of time. I also thank Mr. Shishira Rudrappa, Managing Trustee IDIA, Mr. Amit Datta, Partner Sai Krishna Associates, for sharing their experiences with Mr. Dr. Shamnath Bashir. And I'm sure that the way we look upon IPR and the legal education will change with this inspiring experiences and words they have shared. I'm also grateful to Mr. Mihas Bashir, partner at Wadia Gandhi, and brother of Shamnath sir for joining with us. Your presence is a great inspiration for us. Thank you, sir. I also thank all the resource persons who have agreed to be there with us for the symposium to contribute in the plenary session and also to chair the technical sessions. Thank you, sir. Thank you, ma'am. I would also like to thank our director, Dr. Sarfaraz Ahmad Khan, for providing this platform with constant support. I thank all my colleagues for the support extended by them. I also like to specially thank Mr. Ramesh, our IT coordinator, for providing his technical support for organizing this event on a virtual platform. I thank all the organizing team, Team CIPRA, for their efforts. And finally, I'd like to thank everyone for coming together for this national symposium. And I am expecting that you all will be having great learning experience today. Thank you. Thank you once again.
Thank you so much, ma'am. With that, we've come to an end to the inaugural session. I would like to thank all the participants and the guests who've taken time out of their busy schedule to be with us here today. And we'll wait for a couple of minutes before we begin with our plenary session, which will happen in this forum as well.
Navneet,
Yes, ma'am.
I have made a few of the presenters as panelists. You can start.
Okay, ma'am. Perfect. Uh, Good morning, everyone. I, Navneet Dogra, would once again like to welcome you to the first plenary session which we have in terms of the National Symposium on Intellectual Property Right, being organized by the Center for Intellectual Property Research and Advocacy by Symbiosis Law School, Hyderabad. Before we begin with the plenary session, I would like to remind everyone that we have six panelists for the first plenary session, and then the next plenary session shall continue after the lunch break. So now, without further ado, I would like to introduce the first presenter that we have before us today, Dr. P. Sri Shudha. Ma'am is an associate professor at Damodar Sanjivia National Law University, Visakhapatnam, and has done her BCom, BL, LLM, PhD from Andhra University, Visakhapatnam, and has also done her LLD from National Law School of India, University, Bangalore. Ma'am began her career as a practicing advocate at the Visakhapatnam Bar and has represented several cases before the CSTAT in Bangalore. Ma'am's specialization includes international trade law, e-commerce law, intellectual property law, and tax law. To her accreditation, ma'am has published two books and has published more than 104 publications in reputed international and national journals like the Amity Law Journal of Dubai, the Excise Law Times, the Service Tax Review, and the Chartered Accountant India, to name a few. Apart from this, ma'am has presented 19 papers at international conferences and 52 papers at national conferences and has delivered 21 guest lectures and 5 training programs and workshops. Ma'am has served as a visiting faculty for the Geetham School of International Business, the Geetham University, and has the assistant editor for the Journal of Academy of Juridical Studies. I would like to take this opportunity to welcome ma'am and thank you so much, ma'am, for taking out your time. If you're ready, ma'am, you can move ahead with your presentation.
Thank you, Navneet. Thank you for the opportunity. Can you make me as a presenter so that I can share my PPT?
Ma'am, Ramesh is doing that. As in, yes, ma'am, it's been done. I would also like to request all the panelists that while the presentation is being going on, they can mute themselves so that the presentation goes on without any delay.
Good morning, one and all. Is the PPT is visible to you?
Yes, ma'am.
So today I would like to discuss something about role of IPR for sustainable development from a developing.
Ma'am, sorry to intervene. Ma'am, you are not audible, ma'am.
Okay, let me. Am I audible now?
Ma'am, very low volume, ma'am.
Now? Am I audible now?
No, not much, ma'am.
Keep your audio receiver near you, madam, so that.
Tell me, I couldn't get
Yes,
it.
madam.
Am I audible now?
It is very low, madam.
I have increased the volume also.
It is very much low, madam. You are audible, madam, but it is very much low, madam.
Ma'am, if you could, hello, ma'am, if you could try keeping the audio receiver close to your mouth, if that would be
Right, madam.
Okay, am I audible now?
Yes, ma'am. Yes, ma'am. Much better, ma'am.
Yeah, thank you.
Please carry on, ma'am.
So friends, today I'll be discussing something about role of intellectual property rights for sustainable development. So this concept was introduced at WIPO in the year 2004. After that, at UN level also, they have formulated a particular policy that explicitly deals with this sustainable development. So based on that, certain objectives were introduced under the SDGs. So today I will be discussing those aspects. So basically I have prepared my presentation for half an hour. As the time is less, I'll be focusing on key aspects only, very pertinent issues where we can learn the experiences from United States of America, Australia and Europe, wherein they were so successful in linking intellectual property rights for the purpose of sustainable development. So basically, when we speak about development, the United Nations has fixed certain parameters for the purpose of measuring these developments. So initially, the journey towards development was began with the help of Millennium Development Goals with certain fixed targets as well as a scalable outcome. So certain fixed targets we are unable to reach during Millennium Development Goals regime. That is the reason why the UN has proposed special development goals in the year 2015 to 2030. So if we look towards these SDGs, they speak something about how to develop public and private partnerships between developing and developing countries for the purpose of promotion of this sustainable development. And moreover, nowadays, out of all intellectual property rights, the data is a invaluable IP asset. So, for promotion and commercialization of data which is with developing countries as well as least developed countries, certain mechanisms were prescribed under the aegis of these SDGs. So basically, these SDGs are divided into 17 goals with 230 indicators and certain specific targets aimed at both developed, developing and least developing countries. These 17 goals should be achieved before the end of 2030. So this is the benchmark fixed by United Nations. So friends, at the time of fixing these SDGs, certain objectives were also created for the purpose of linking IP with these special development goals. So yesterday when I was referring certain articles authored by renowned authors, so Professor Ovet, she has described how this IPR is very much responsible for achieving these SDGs as well as sustainable development. So she has basically emphasized upon a few important aspects. Basically, each and every state is obliged to partner with member states for the purpose of achieving these sustainable development goals. And after that, these SDGs are also emphasized on protection of traditional knowledge. So specifically, goal number 17 of this SDG speaks about how to protect this TK as well as commercialization of this TK. So in India, we know very well about that the turmeric is having the antibacterial quality, and in connection with the turmeric dispute also we have successfully revoked the patent which is conferred to the Mississippi University of United States of America. Likewise, these special development goals are focusing about identification of traditional knowledge which is with the community and how to commercialize this traditional knowledge and give that benefit sharing to the community who are 100% dependent on this traditional knowledge. So for that, let me share a success story in connection with commercialization of indigenous knowledge which is owned by a nomadic tribe community which is there at Australia. So at Australia, a sandalwood growers organization popularly known as Mount Romance. So they have collaborated with a multinational corporation, Aveda, for the purpose of extracting sandalwood oil from the trees and make use of that sandalwood oil for the purpose of manufacturing of uh, world-class perfumes, aromatic solutions. Likewise, my dear friends, at Australia, they were so successful in commercialization of this IK. And moreover, in the year 2004, they have formulated a particular protocol with the support from World Perfume Conference for the purpose of sustainable usage of the sandalwood. So like Australia, in India, we have certain invaluable biodiversity species like red sandalwood. So in the state of AP, especially the Rayalaseema districts are very much popular for this red sandalwood. But unfortunately, that wood is subjected to uh, smuggling activity. Many people are badly affected because of this. So if we take certain measures for the purpose of commercialization of this rare variety, the community who are dependent on that sandalwood will get benefits out of it. And after that, uh, promotion of culture and heritage. So when we speak something about development, many cultures are subjected to so much distraction. So, but at Australia, the traditional cultural expressions are well protected. So regarding the protection of that traditional cultural expression, uh, Kelly, he's a folk person, he said, how you are preserving your culture being a fisherman and how you are protecting the fisheries who are there near to your village. Then what he said is, being a native tribal people, we know how to catch the fish. At the same time, how to uh, conserve it for the future generations also we were told by our elders. So likewise, at Australia, they are trying their level best for the purpose of conservation and protection as well as commercialization of their indigenous knowledge. And after that, I also read something about the cultivation methods at Indonesia as well as Sri Lanka. Certain tribal community, they know how to protect their rare varieties of staple food as well as cereal food. So regarding this protection of indigenous knowledge of cereal varieties, at Kerala we have a success story. So Navara rice producing community, it is a registered organization. They have registered a GI rice variety, again is the name of Navara rice production community. So likewise, in India also we have certain few initiatives, but compared to these countries, we need to learn many more things. And after that, at Canada and all, whenever we are using a GI related product in India, we are not fixing a label or a trademark against a GI product. But whereas this marks indicative of condition of origin, this MICO, they have come out with a wonderful initiative in such a way that if a particular produce, it may be an agricultural related issue or else a foodstuff which is manufactured or originated from a particular territory, the name should be labeled against that so that the benefit will directly reach that community. So very recently, from our university, we did a case study regarding Araku coffee. So in the year 2018, uh,
the Araku coffee got its geographical indication protection. So that GI was transformed in the form of a trademark by Nandi Foundation. So today at European Trademark Office also this Araku coffee was registered as a registered trademark. So likewise, dear friends, in India till today we have registered around 323 geographical indications. Out of 323, I can say that the Pashmina shawls, this Navara rice from Kerala, and this Arku coffee as well as Darjeeling tea. So besides these four products, remaining products were sold without any label or a trademark. Because of that, many GI products are subjected to duplication. So even though certain sellers are selling duplicate products of these GI things, they are unable to uh, take any kind of legal action. So that's why today I am proposing one thing in such a way that like this micro initiative in India also, if we develop such kind of labeling of GI products, we can protect our culture as well as our products from piracy as well as from duplication. And after that, one more important aspect mentioned under these special development goals, wide chapter 34, agenda number 21. So that speaks about transfer of environmentally sound technologies. So when I went through the paper which is released by Niti Aayog, after this Paris Pact, Government of India has taken an initiative for the purpose of production of large scale solar energy as well as wind energy. In India, when we have developed our own technology for the purpose of protection of this solar technology, many companies have filed a suit before WTO. So, though Government of India has taken certain initiatives for the purpose of production of environmental friendly power, so this technology is with Western countries. Still, they're not coming forward to transfer the technology with viable terms. So this is also one of the most important aspect we need to discuss upon. And after that, this agenda number 21 also speaks about promotion of multilateral environmental agreements. So if we examine our multilateral agreements as well as bilateral agreements, every time we will focus about tariffs or else customs free zones rather than protection of this environment. For example, when we speak about innovation as well as manufacturing activity, we will take example from China. Yes, today China has emerged as a global leader in manufacturing activity, but at the cost of environmental degradation. So, being a communist country, every time their focus is about monetization of intellectual property rights. So, they have completely destroyed the environment, especially the level of air pollution and water pollution levels are more at China. So that is the reason why this SDG specifically speaks about when you are recognizing a particular intellectual property right, whether these multilateral forums are discussing about protection of environment or not. And regarding this environment sound technologies also, this SDG wide goal number 3B specifically speaks about um, environmental friendly means pollution free environment as well as access to medicines for all. So in connection with that only, India and South Africa, very recently, before the TRIPS Council, both the governments have submitted certain flexibilities in connection with production of COVID-related drugs. And after that, Yes, DG 17 specifically speaks about promotion of public and private partnerships uh, in connection with commercialization of these intellectual property rights. And for the purpose of strengthening this initiative, WIPO has launched a wonderful initiative that is WIPO Research. So it is a open source database. Whoever is researching in connection with environmentally sound technologies or green patenting, they can access materials from this WIPO research. And after this, WIPO has taken one more initiative, that is Accessible Books Consortium. So with the help of this also, um, the specially challenged people, disabled people are in a position to access these free books. So friends, likewise, this medicine patent pool initiative is also very much responsible for development of HIV drugs as well as tuberculosis based drugs. So friends, likewise, when we speak about development, these based on these SDGs, a global platform like WIPO is responsible for development of these kind of IP sharing models. Based on that, being a developing country, we can get benefit out of these initiatives. And after that, SDG 16 specifically speaks about promotion of peaceful and inclusive societies for sustainable developments, which will equally provides access to justice for all. And further, it is very much responsible for building an effective, accountable, as well as inclusive institution at global level. So likewise, these SDG number 16, 17 are very much responsible for ensuring an equitable society and a sustainable society. So friends, with these insights, I am hoping this seminar will discuss more and more about the sustainable technologies so that uh, we can protect our environment for a better future. So I thank the organization for giving this wonderful opportunity. So if you want, you can go through these articles. So these two research works are very much responsible for promotion of this sustainable development, the linkage between IP and sustainable development. So thank you for the opportunity.
Thank you so much, ma'am. Ma'am, before we end your session, I just want to apologize on our end that your video was not being displayed because like there's some issue. So I would again like to request all the panelists to kindly switch on their videos for the entirety of this the first plenary session. Ensure that you're muted so that we are able to depict that all the panelists are present. Would that be possible, ma'am? Um, Dr. P. Sri Sudha, ma'am, would you be able to turn on your video again?
Yeah, I couldn't get you. Could you please repeat?
Ma'am, so there was an issue in terms of your video not being on during your presentation. So it's a request to all the panelists that your video should be kept on, but you should be muted during the entirety of the plenary session. Only when you're presenting, you can unmute that yourself. Would that be fine, ma'am? If you could like switch on your camera.
Yes, yes, I can.
Perfect. Thank you so much, ma'am. Thank you so much, ma'am, for this amazing presentation. And we are hoping that there's some developing that the Center for Intellectual Property Research and Advocacy could do as well in terms of the guidelines that you've stated. Moving further, now I would like to request Parikshit Sirohi who's the assistant professor at the Faculty of Law, University of Delhi. Sir has done his BCom from University of Mumbai, has done his LLB from University of Delhi, LLM from Guru Gobind Singh Indraprastha University, Delhi, and PhD from Jamia Millia Islamia, New Delhi. Sir has been invited to deliver lectures at the Competition Commission of India, the RCVP, the Haryana Academy of Administration, the Haryana Institute of Public Administration, and the Department of Science and Technology, Government of Rajasthan, as well as the CBI Academy in Ghaziabad. Sir is a visiting faculty for the LLM IPR program at the Maharaja Surajmal Bridge University, and this was during the years of 2017 to 2020. Recently, Sir has authored a book titled "Interface of Design Law with Copyright Law and Trademark Law," and has co-edited another book which is titled "A Critical Approach to the Right to Information Legislation in India." Apart from this, Sir has contributed book chapters to various national and international publications, and presently, in terms of food security law, Sir was awarded his doctoral degree on the topic of food security law in India, an endeavor to tackle the problem of hunger through legislation. Today, Sir shall be talking about his presentation on a comparative study of various jurisdictions in terms of fair use and parity effects. Sir, if you can kindly present your screen.
Yes, thank you very much, Navneet. I would not be making a presentation because I sometimes feel that, when I'm dealing with young people, and I assume here we are all young people, sometimes with all due respect to all presenters, sometimes the presentation takes away from what the speaker is saying. So I have a presentation. I will send it across to you or the organizers of Dhanya ma'am, as the case may be, and that can be circulated. I have no problems to it. But I would be liking to speak extempore because I have a topic which is of very, very relevant contemporary importance. So I hope that is okay. And so, first of all, my sincere thanks to the organizers of this program for. Am I audible? Am I visible?
Yes, so you're audible.
Yes, yes. Thank you very much. So, first of all, at the outset, my sincere gratitude to the organizers and the entire team who have put together such a beautiful program. And I've been hearing the deliberation since the morning. We have spent 2 hours, and I have not even realized that there is any kind of monotony because there is such a diverse range of subjects that people have been discussing. So, my sincere congratulations to the entire team, Professor Sarfaraz Ahmed Khan Sahab, the director of Symbiosis Law Schools, Hyderabad, Danya Madam, who is the assistant professor and also the in charge of this CIPRA cell that you have, and the head of the organizing committee of today's program, all the student members. You've done a fantastic job, guys. So we must all be proud of what you've done. I would like to spend about 30 seconds on talking about my association with late Shamnath Bashir, sir, Professor Shamnath Bashir, somebody who became a professor, a full professor in his 30s, and through his sheer hard work, and I have worked with him very extensively in the DU photocopy case, Rameshwari photocopy as we know it. He won the case against the publishers, the whole use of fair use of textbooks, on the patents case, on the right of law teachers to practice law. So on a lot of factors, and like previous speakers have spoken, it feels very odd to speak about him in past tense, but I'm sure he would be very happy if he sees the kind of work that Shishir, as a very good personal friend of mine, has been doing in his memory. And all the speakers today have been, with all due respect, excellent presentations by James sir, by the other panelists. And so I must all of these people have worked with Professor Shamnath Bashir, Professor James, Mr. Datta, Dr. Tripathi, and Mr. Trivedi, so Professor Reddy. So, FCRA clearance for his organization, the pride that he took in introducing each of his charges at any conference. Oh, this is, my student, and she is from this family. Her father sold idlis, and her mother, did this work. And look, she is in NLU this, and she is topping. You would have been very happy with what Yamuna Menon has achieved. The number of gold medals she has got in Bangalore, and that's why I said Shishir and company are doing such good work in his memory. So now coming back, friends, to what I am going to be talking about today. I am going to be talking to you today about something which is very, very essential essential in today's contemporary times. And so I'm going to be doing a comparative study basically of various jurisdictions. And the title that I have is Fair Use and Parody Rights, Comparative Study of Various Jurisdictions. I'm going to be looking at 3 or 4 jurisdictions. And I will try and find up in the time allotted to me, but if I don't, please bear with me for 5 minutes extra. And I request the organizers' indulgence for that. Because the topic is a little bit, one has to go in depth. And once you understand this as students, you will really want to work in this area. What is the legal interest of an author? An author is somebody who creates a work. Now, in the work, what is the legal interest of the author in the work? This is the question which has been haunting the pundits of copyright ever since Gothenburg's Bible came in, and ever since the first printing press was invented in the 15th century. And because mass dissemination of ideas became possible for the first period of time, and this mass dissemination gave the ideas economic value. Modern society has intensified this challenge because with the advent of modern technology, creative arts are now big business, and the arts previously were for patronage. So you must have seen that, Akbar, Birbal, all these people would be Akbar, and all these people would be patronizing the sculptures and the artists and whatever. Now it is no longer about patronage, it is about economic returns. So that's why we talk about moral and economic rights, but that is a topic for another day. My presentation basically has 4 objectives. Firstly, I'm going to talk about the concept of parody and understand as to how it is different from other analogous things such as pastiche and satire. We will come to it. Satire is, you make fun. Pastiche is you use it in humor. We will come to each of them, don't worry. The second is we are going to be discussing various parody exceptions and fair use provisions in other jurisdictions like I said India, US, UK, etc. So that's why the comparative study comes in. The third is the compatibility or incompatibility that we see today between moral rights and the idea of parody. So they are actually opposite to each other. Moral rights say that you cannot show my work in poor light. Parody says, you have a right to make fun, well, up to a limited extent. So what is the incompatibility which exists? The last objective is to see how digital technology has changed the way creative works are exploited, viewed, consumed, and what changes, if any, are needed to law to satisfy these. So this is my topic for you, friends. We take them one by one: parody, petition, satire. Parody you find everywhere in contemporary culture. You find it in literature, theater, TV, architecture, even everyday speech. How I am speaking, how I am delivering, how my tone, how my modulation is there depends upon whom I have learned, and it happens subconsciously at times. Many a times I find myself speaking like my boss. It happened because he was my teacher 15 years ago, a gentleman called Professor Mahavir Singh. I find my modulation is like his. The another day I find myself being speaking like my teacher of IPR, who has been Dean of Faculty of Law. He was my teacher of IPR 15 years ago, Professor Raman Mittal. So this is how it is there every day, and sometimes it is subconscious also, like I'm telling you. Now you must understand what is parody and what is the difference between the other forms of petition satire. So parody from Greek and Latin actually signifies a form of जिसका आप मजाक उड़ा रहे हैं, mock poetry which is used in a manner and diction and applied to a trivial topic. It is also denoted in more widespread use as a more neutral practice of quotation and allusion. I allude to something. I say, excuse me, that the boy who was wearing a red shirt, I don't take the boy's name. There's only one boy in my class wearing a red shirt. It is obvious who I'm talking about. So this actually is a form of parody. In neoclassical usage of 17th, 18th century, parody was no longer only an illusion. It is now something bigger. With the passage of time, parody has become something more. So KFC wanted to open a restaurant in Aurangabad and call it Khakra Fafda Chakli. It was not allowed in copyright law. But KFC's Kentucky Fried Chicken, they said, look, our brand will die. So fair use versus parody is another topic which I said. Parody attained a very restrictive meaning over the passage of time, and in the predominant usage, it is only as a critique. But the essential element is even today humor. So the one of the most widespread definition of parody today is, and if anybody wishes to take note, I will be very slow. A parody is a work of art. A parody is a work of art, the central theme of which revolves around an existing work of authorship. Central theme revolves around an existing work of authorship. Main purpose is to criticize. Main purpose is to criticize the earlier piece of art in a humorous and mocking manner. So there are two features which come out. First is the work is based on an existing work. So the work will necessarily become a derivative work. And the second is you have to criticize, albeit in a humorous manner. Now, Patish, it is pronounced as Patish and written as Pastiche. Patish, on the other hand, is a work of art which imitates the central theme, the central characters, the central scenes, the central situations of the original work. So that is, it imitates. I'm just writing in the chat box in so that you can all see. 1 second to all participants. Yeah, chat box. Okay, I'm just writing here, and this will go to all of you. Yeah. So this is what Patish is all about. So Patish is, on the other hand, it is a work of art which imitates the central theme, scenes, characters, situations of the original work. Dominant work is not to criticize, but only create an association. So famous author Jameson defines Patish as a true satire, which not only criticizes but also makes you laugh. Also makes you laugh. Making you laugh is not the essential part. Brings satire very close to parodies. Satire is not necessarily based on authorship, as is the case of parody and pastiche. So we have now understood parody in general. We will look at national copyright laws of different countries. So the main problem in copyright law, as you're already aware, friends, is that the concept of territoriality is there. Territoriality is there, and that is a major problem in copyright law, right? So territorial nature of copyright laws, and we are now going to be looking at these three positions of major countries. The Congress in US has a constitutional grant to promote the progress of science and art by securing for limited times the author's rights. So 100 years. Authors, I think there is somebody unmuted. There is some disturbance in the background. May I request the others to please mute themselves? There is some disturbance. Anyway, no problem. We will continue. So the Congress has the power to make laws to promote science, etc., by giving the inventors or the writers exclusive right over the writings for certain period of time, 100 years. This is not an end in itself. This has made the Congress and the courts quite receptive of the practice of parody. So parodies are not seen as threats to authors' rights, but parody ka purpose is that you create independent art which is capable of generating a separate market for itself. Based on the doctrine of fair use, now, don't copy the central idea or theme. You develop your own theme. Yeah, the main idea you can have, the idea expression dichotomy, right? So you don't have verbatim copying, but very rarely will you have a case of verbatim copying. So you basically lift an idea, sequence, story, and then you develop something based on it. There may be a case which is happening in the case of digital parodies that the court finds that there is substantial copying. Now, this is Justice Story's decision in Folsom case, FOLSOM, and he is defining fair use as a use which will not seriously discourage progress of science and art. And social value greatly outweighs any determinant to the artist whose work is being borrowed. Social outlook is social good prevails. Okay. And he says that this four-factor test has to be done. Now, this four-factor test has become Bible for American lawmakers, American jurists since then. What is the four-factor test? Nature and objects of selections made, quantity and value of the material used, degree which may be used to prejudice the sale or diminish the profits of the erstwhile work, and lastly, supersede the objects of the original work. Now, this has been used every time. Most, if anybody is interested, read the judgment of Campbell versus Acuff Rose Music. Campbell versus Acuff Rose Music. I will just type the name of the case, and it is Campbell. This is it. And so, just anybody can who's interested may have a look at this case. And the citation is 510 US. I'll just write that also, please. So this is the citation of the case. Anybody interested may have a look. So this is where they have used it, and the facts of the case are very interesting. Roy Orbison and William Dees write a song called "Oh Pretty Woman," and the rights go to Acuff Rose Music. The song becomes very popular. There is one person called Luther Campbell in 1989 who comes up with an obscure band called Two Live Crew. He rewrites the song, substitutes the lyrics, but the tune is the same. Campbell's music company Luke Records releases this album and gives the credit in the album to this person. Oribson and Dees as the writer and Acuff Rose as the publisher. District Court gives the verdict in favor of Campbell and says it is fair use. However, the Circuit Court goes back to the case of Universal Studios Corporation of America and says that this is not fair use and it is infringement because you are blatantly copying for commercial purpose from a derivative work. And it is not going to be a derivative work because you are blatantly copying. I will just try to wind up from the US side. So this is, and now the UK. The UK again has had a very long and bumpy road towards this area. There is no explicit parody position in the UK, but scholars like James Banco have questioned the use of the substantial use test, which has been applied prior to 2014. And so there is the case which comes up right from 1894, and this case is called this. This is the name of the case, friends. It is an 1894 case. And so here what we are seeing, friends, is that the well-known artist Empire Theatre had produced something, tableau, jhanki kind of thing, and there is somebody else who makes sketches of this tableau and starts publishing it. The defendant's stand is accepted by the court, and they made a mistake. They say the rough sketches are made for very different purpose. The purpose is not to give an impression of the pictures, but a rough idea. So this is the position, and then there was a 2014 amendment which has again not defined parody, caricature, or pastiche, and left it to courts to determine. Then there is a Deckman case, which we will not be able to discuss in detail, but I will just leave you with that case's name because of paucity of time. So this is the leading case which is there in the UK. You can have a look in your own time. And so then there are standards provided, etc. Now we come to India. In India, like the global trend is there of providing protection to creators of derivative works, India again amended the act in 2012. And previously, we were not providing exception for parodies, but in 2012, we amended Section 52. And now we say that fair dealing of any work which is not being a computer program. 52(1)(a) is what I'm reading, for the purposes of private or personal use, criticism or review, reporting, etc. So this is coming within that. There are very interesting cases from Kerala. Civic Chandran is one case. Civic Chandran is one case, and then there is a case which which is involving two leading Malayali plays which are based on communism. I mean, in this Civic Chandran case, there is a two play, which is the two things which are there, and I'm just giving you a little bit. You can read it. So there is this is two plays. One is Ningal Are Kominatski, which was based on an original play called Ningal Ene Kominatski, written by a very famous Malayali playwright called Basi. And the Kerala High Court's decision is very interesting, and I would want you to read it. The contention was that it is emotionally connected. The second play is emotionally connected with the first one, inspiring communal sensibilities. So it is held to be a counter drama. So this is the position, and now we need uniformity of law, and moral rights become important for the creator of parody as well as the original author. In the digital era, we have to look at the rise of technologies, how you can come in. Tata Sons is a very interesting case. Tata Sons, very interesting case of Tata Sons is there. I will just quickly tell you about that case. And the use of the word tea, right? The Greenpeace company has started to be used, and without authorization of Tata Sons. Now, this is Tata Sons claim that it is our logo, it is our trademark, and whether you are using it for parody or whether it is not, that was the question in existence. Now, friends, my question to you is: in US, UK, and India, we have taken three very different routes. US has been at the forefront of embracing new art, even in the absence of explicit provision for parodies. The position is not very satisfactory or very clear in UK and India. And it is a very ripe opportunity for WIPO, according to me, to come forward and propose a uniform law dealing with minimum protection to be provided for parodies across jurisdictions. All such complications which arise in application of general doctrines of fair use and digital dealing will also go away, and there will be a clear and stable law for all future times, so there can be unhindered creation of parodies within the realms of law. So this struggle between the original author and the owner of the parody will, I think, be dissipated to a very large extent. So that is it from my side. It is over to you, Naveen, and if there are any questions, I'll be more than happy to answer those. And apologies to the organizers, I've overshot my time by 5 minutes or so. My sincere apologies.
Thank you so much, sir. So the question answer session shall be at the end of all the panelists' discussions. We will collectively ask the questions, and I will be posing for the questions. So this is just to remind all the participants over here and the attendees over here that you can use the chat box to post your questions, and at the end of the session, we will use 10 to 15 minutes to deal with all the questions. I would like to thank Sir once again. Sir, as a personal enthusiast in terms of parodies and movies, this is such an interesting topic for me to understand and revel in. I'm pretty sure all the attendees would have done the same, and we're hoping that there can be development on this aspect of law as well. Now,
Thank you.
Thank you so much, sir. Now, I would like to call upon Dr. Varsha Deshmukh. She's the Associate Professor at the and the Coordinator Research Center of Dr. Punjab Rao Deshmukh College of Law at Amravati. Ma'am has done her MA, LLM, and PhD, and she has done her PhD in human rights law. At present, ma'am previously worked as an ex-officiating principal at the Vinayak Vidhi Mahavidyalaya and worked at the PGLLM Department of Law. Ma'am has also worked as the academic staff of the SGB University Amravati. She was the coordinator of human rights diploma at the YCMOU Nashik and has done major research project in law and was sponsored by the UGC New Delhi. Ma'am has acted as a resource person and guest speaker in terms of All India Radio Akashwani, chaired international conferences, published articles under the same process. And most of Ma'am's work relates to domestic violence, female feticide, child abuse, women trafficking, and Ma'am has been recognized internationally as well as internationally for the same. For today's session, Ma'am shall be discussing on the interface of human rights and intellectual properties with an Indian perspective. We are really honored to have you here, ma'am. And ma'am, if you could turn on your video and present your screen. Dr. Varsha, ma'am. Ma'am, you have muted yourself or you've not turned on your camera. Ramesh sir, can we ensure that ma'am is a panelist?
Name, please.
Dr. Varsha Deshmukh.
Yes. Now I'm okay. Can I share my PPT?
Madam, it is
Share
echoing,
my
madam.
PPT?
Yes, madam, it is echoing in your sound.
Yes, ma'am, you can share your PPT. If I may intervene, would it be possible if you could use earphones, or would this be the setup that you'll be using for your presentation?
Yeah, I'll just share my PPT. So viewers, it is indeed educational first because my core area of study is human rights, and today we will see the interface of human rights and IP. Let me share my screen. Is it visible and am I audible now? Amnik?
Ma'am, you're audible. I'm just waiting for the PPT to load. Yes, ma'am, your PPT is visible.
Is it, yeah, you can see this now?
Yes.
Okay, let me start with the basics of the intellectual. Although it will, we heard many resource persons and are very latest about the IP, but the topic today is interface of human rights and the intellectual property. Like IP deals, everybody knows that IP deals with the intellectual intellect and the protect creation of the human mind and commercial interest. The HR protects the dignity, equality of the individual, and well-being of the people. Protect public interest. So today in this session, I would like to focus on the public interest. It has been observed both areas are interrelated with each other, but they are in a fundamental conflict with each other. We know that these are the agreements that we are signatory to the IP regimes like Berne Convention, Rome Convention, Geneva Convention, and especially we speak where we have a connection and then conflict. There is the like copyright and of course the neighboring rights like patent and other things. Let's speak about human rights, which how they are connected to the IP. That UDHR 1948 protects authors' moral and material interest in their scientific, literary, or the artistic production. This could be seen as a direct reference to the IPR law. When the economic and the social and the political right came into view, the interconnection between IPR, this is the interconnection. Because of this, the human right has a connection with the IP. The IPR infringes the right clause, especially when the economic, social, and cultural rights are concerned. IPR neglects indigenous communities, as Madam also mentioned about it, and the social implications of the TRIPS agreement. According to the IPR rating, traditional knowledge in in consideration a part of the public domain since it does not meet the established criteria for the protection of traditional knowledge, and also many private enterprises use this knowledge for the further invention and protect their inventions through the copyright, patent, etc. The it is like it is deprivation of their legitimate share and it leads to the violation of human rights. The respective governments can protect the traditional knowledge by denying patent, copyright, and should enact the legislation community damage or the authorized uses of traditional knowledge, as we have seen even in the Bollywood booklets and some traditional knowledge are used and they are making money out of it. Indigenous population are deprived from this the point. The controversial points when we see that TRIPS agreement admitted the high minimum standard for the IPR protection. Even the WTO members not compliance with the term of the agreement can result into trade sanctions. So when we speak about the underdeveloped countries, it has a negative implication for underdeveloped. It comes the protection comes almost zero. If we violate, we cannot meet with the minimum standard of protection for the patenting the pharmaceuticals, and there are restrictions to exercise. We here the another area of violation is that. Thirdly, the food insecurity. Introduction of IPR in agriculture can only be justified if IPR fosters food security. Developing countries are enhancing challenge before policymakers. Introduction of IPR in agriculture needs significant changes in the policy environment and for addressing the food agro biodiversity and the food biodiversity, which is the major hurdle of the human rights if you study in detail. And if it agro technology includes the development of plant varieties that meet the challenges to existing food insecurity. TRIPS does not give developing countries protection of plant variety. The sui generis gives an opportunity to develop IPR regime according with the international obligation. Here are, even I can quote that many cases, like even in India, the Patanjali has patented by using the aloe vera, haldi, and then giloy. And this pandemic, the giloy is very useful. And through this, I think they are benefiting a lot, but their individuals' right or the indigenous population or the people who are the rural area, they're deprived of this, their share in the benefits. Then food needs and UPOV convention, of course, the International Union for the Protection of a New Plant, as only 2076 members are signatories to this convention. The UPO has been promoted, but developing countries need protection of traditional knowledge in general and farming communities, especially underdeveloped countries. The member states need to develop legal framework to protect traditional knowledge beyond the IPR model, because IPR doesn't have any protection of the traditional knowledge. When we speak about the moral rights, intellectual property regime requests to balance between the economic rights of the actor and the inventors with the broader design society. A major justification for patent and copyright is that incentive and the reward to inventor result in the advantages of the society. A person's right approach to holding takes what's usually an implicit balance between the rights of inventors and the creators. When we, hello.
Yes, ma'am, you're audible.
Am I now? Okay. So when we speak about the moral rights, the foremost thing is the moral rights as special set of rights that are owned by the author or the creator of a work by virtue of their role as the author or the creator. And then the right of attribution, also called the right of paternity, it also called as a right to integrity. And this Indian Copyright Act 2005 provides the perpetual moral rights, and the moral rights in Article 6 are for the proper attribution and against any distortion, mutilation, and other modification of the work, where the act would be or be prejudicial to the reputation of the author. So the moral rights are very much considered, and the IPR definitely the violating the moral rights and as well as the human rights in general. There is a gap in developing countries must fill, given that their agricultural system are often depend on the contribution of a significant number of small individual farmers. Local farming and the public sector are significant rather than the private sectors. The development of the positive farmers' right are necessary for the benefit of the farmers and the countries, and the develop sustainable agro biodiversity management and provide tools to fight biopiracy and the incentive to tackle food insecurity. Hence, existing IPR should be complementary to human rights, and this part we really have to develop some, fill the gap and develop some legislation for the protection of the human rights of the citizen. By this conclusion, I conclude my presentation. Thank you so much. I hope I'm within time.
Yes, ma'am. Thank you so much for
within time.
Yes, ma'am.
Yes, yes.
Indeed, you.
Thank you
I
so
would
much.
like to thank you for providing us with this presentation on the interface between human rights and the intellectual property in terms of biopatents and in terms of pharmaceutical patents as well. Now, I would like to request all the participants and the attendees that if you have any questions, kindly you either use the chat box or use the Q&A session to post your questions, which we shall be reviewing at the end of the sessions, at the end of the first plenary session. With that, thank you once again, ma'am. I would now like to invite our next speaker and presenter, Dr. Victor Webb of London, who is an advocate and patent agent at Sai Krishna and Associates. Now, Dr. Victor Webb of London is an academician turned lawyer, and prior to his work at Sai Krishna and Associates, Sir taught at the RGNUL Patiala as an assistant professor of law. Now, Sir obtained his bachelor's degree in chemistry, followed by LLB from University of Delhi, after which he pursued his LLM from Indian Law Institute, New Delhi, in which his specialization was intellectual property law. Sir had secured the top rank in his batch in terms of his LLM. His PhD research, in which he conducted as a junior research fellow of Government of India, compared the patent eligibility norms for pharma biotechnology innovations in India. He's also a visiting faculty for PG Diploma at IPR at Indian Law Institutes and the Indian Society of International Law. Sir has contributed towards developments of MOOCs, YouTube Live, and audio lectures on law for senior secondary students for NIOS. Now, Sir's articles on patent law have been published across IPCAT and Spicy IP, and Sir more or less focuses on pharmaceutical patent litigation, as had been mentioned before. So today, Sir shall be imparting his research and guidelines in terms of Section 3D relating to innovation and access to medicines in terms of the Indian experience. We're really honored to have you, Sir. And if you could present your screen and turn on your video, it would be perfect.
Thank you, Navneet. Am I audible and visible?
Yes, sir.
Okay. Could you just guide me as to where would be the button for presenting my screen? I am not.
Please click on Quick Start, sir. Click on Quick Start.
Quick Start. Okay.
Yes. There is an option, sir. Share your desktop.
Share my desktop. Yes.
Right. Thanks.
Is it visible? Is the PPT visible?
Yes, sir.
Okay. Thank you. So I will take on from here. Thank you so much, Navneet. And first of all, my warm greetings and congratulations to SLS Hyderabad for organizing this wonderful event, Symposium, and for giving me the honor of being part of such a wonderful gathering of IP stalwarts. Some of whom have been my colleagues and some of whom are my seniors. So I would be speaking on Section 3D and innovation and access to medicines. I will try to keep it short. And as you can see on your screens right now, there are several provisions within our Patents Act which have ramifications for public health. I won't be dealing with all of them, obviously, and I will only focus on Section 3D, which deals with two aspects, the anti-evergreening aspect and the anti-second indications aspect. And before I start, I will be focusing on the current developments. And as I promised Professor Dhanya that I would perhaps leave some of the students here who are watching this event with pointers as to where perhaps they can pursue research in the future. And this will be based on my experience in practice. So Section 3D, this clause has been the bone of contention and a source of resentment for a lot of developed countries and the big pharmaceutical lobby. If you guys are aware, as part of US Trade Representative's Special 301 report, time and again, India has been put on the priority watch list of countries whose IP laws are problematic, and US, EU, all the big pharma companies have a specific problem with this Section 3D or the anti-evergreening clause. I will come to the reasons shortly. They have also pointed out to the existence of compulsory licensing, revocation regimes, working statements as problematic issues and issues which perhaps make India an anti-patent jurisdiction, which of course we have always argued is not true. And therefore all these clauses in front of your screens right now, they have been a source of conflict with regard to international trade. They have been part of politics. They have been part of power struggle between big pharmaceutical companies, all of whom are based invariably in US, European Union, and Japan, and our Indian generic makers. And of course, all these clauses are part of that struggle between rights of patentee and rights of public to affordable access to healthcare, a kind of conflict between right to health and right of patentees. So I will, as you can see, Section 3D in front of you comprises of two parts. Number one, the line in yellow, the portion in yellow, is what is actually the anti-evergreening clause, which essentially says that if you come out with new form of a known substance, there has to be a known substance, and if you are coming out with a new form which is not resulting in the enhancement of the efficacy of that substance, you are not going to get a patent over it. And the second part, the portion in green, is actually the second limb of Section 3D, which is anti-second indications, which basically means that if you are coming with new property or new use of a known substance, for example, there is a pharmaceutical drug which can cure cancer, and tomorrow I find that it can also cure tuberculosis, then this second use or new use or subsequent use, I'm not going to get a patent for that. My patent is for the drug and for its first use that I was able to disclose. And essentially what these two limbs of this clause they do is they prevent repatenting or extension of life of the patent over the same inventions. And by doing so, they allow for the early entry of generics in the Indian market. And these generics, as you are probably aware, they are more affordable, cheaper, and therefore more affordable for the public at large in India. So by curbing market exclusivity, by curbing repatenting of the same invention or extension of patent term for the same invention, these two limbs of this clause, they allow for affordable access to healthcare. And the landmark case, I'll just shortly explain what evergreening is. The landmark case of this was Novartis. I will not dwell too much into it for the sake of time. I'm quite sure that since the judgment came in 2013, much has been written about it, much has been discussed about it. And what flew from this, what came from this judgment, which is a settled law, is that, and this was a judgment on the first part of anti-evergreening part of Section 3D. And the Supreme Court said that it is specifically for chemical substances and pharmaceutical products. And that when you talk about efficacy, enhancement of efficacy of a known substance, this efficacy is essentially therapeutic efficacy or efficacy of producing desirable effect with regard to the properties of the drug. So if that particular drug can cure you faster, cure you better, perhaps that can be called as enhancement of efficacy. And I'll come to the new disputes which have been fought since 2018. And it is over here that I will explain the nuances of this evergreening aspect and what is happening right now. So since 2018 till now, there have been a couple of drugs, blockbuster drugs, namely ticagrelor, which AstraZeneca has a patent over the same, and apixaban. Bristol Myers Squibb has the patent over the same. Now, these are essentially US and European companies which have patents over these two blockbuster drugs. And what they have done is, and this is where the part of capitalism and greed probably comes in, what these people have done is that they don't just patent the active ingredient, the part of the drug which is giving it its medical properties. They don't just patent that, but they also patent the active salts, polymorphs, different forms. By making minute, minor trivial changes, they keep repatenting the same drug. And the idea behind it is that if my one patent has expired, so for example, if my patent over the active ingredient of the drug has expired, I will still have my patent over a particular salt. If that expires, I will still have the patent over a particular polymorph or a different form. If that expires, I will still have a patent for the composition. And come whatever may, I would extend my patent monopoly and I will not allow generic makers to enter the market. I will not allow the price of the drug to be reduced. And specifically in the context of these two drugs, and of course, this has ramifications for right to health, affordable access, because most of the people in our country, considering our economic situation, they are not able to afford some of these medicines. They're quite expensive. So we need generic versions. So these particular drugs, this is a wonderful development which has happened after Novartis. They are in the context of genus and species patents. Genus is a Marcus claim, which is why I will just show you what exactly it is. So the first patent these companies file is something called as a genus or Marcus patent. The diagram which you can see in front of your screens right now, they do not disclose the specific molecule, they disclose the general generic formula. Like, for example, the R and X. So I've given you examples. A Marcus claim is where there are components of a particular chemical which are replaceable. So if you have studied basic science, X can be a halogen, which can be chlorine, bromine, iodine, fluorine, and R can be a hydrogen atom, methyl, CH3, or ethyl, C2H5. And by replacing these, they come to something known as the species. So for example, in the example I just gave you, the simplest replacement of a chlorine atom and hydrogen atom are going to give me the species patent. Now, this is the conflict between genus and species. So they come with the genus patent first of all, and then they also later, 3-4 years down the line, come with the species patent. And by this, by the virtue of these two patents, they are able to stop the entry of generics even after the genus has expired. The basic patent has expired. And this is a very simple example that I had given you to perhaps explain to you what exactly genus species are. This is how complex it actually is. This is the formula of ticagrelor and the drug. And now I will just, it perhaps becomes easier to explain what is happening. So when you look at the science of it, once you have disclosed a Marcus formula or a genus for a person skilled in the art, a scientist, it becomes easier perhaps to do different permutations and combinations based on scientific principles and arrive at the species. It's nothing wonderful or nothing strange or nothing amazing or magical. But by claiming species as a separate invention, these patentees have often tried to inhibit, stop the ability of others to replicate that product and come into the market. And in context of this, generic companies have taken a Section 3D argument by saying that, look, Your genus, as you can see on your screens, your genus covers the particular drug in question. It does not specifically disclose it, that is fine. But the particular species is nothing but a new form of the known substance. It is a derivative which a person skilled in the art can arrive at, and it is a new form of a known substance, which is your Marcus claim or genus patent. So species is the new form of the genus, and there is no enhancement of efficacy between the two. Now, if there is no enhancement of efficacy, and if one is a derivative of the other, new form of the other, you are squarely falling within section 3D or the anti-evergreening clause, which I just shown to you, if you remember that. And this is the kind of argument that generic companies have been taking, and they have come up against these patents, filed invalidation proceedings. The suits are currently going on. And as of now, because trials have not happened, we do not have a particular clarity as to which way the court will decide or which way the particular decision is going to come, whether the arguments of generic companies will win or whether the arguments of the patentees will win. Now, perhaps a lot of us as researchers have been reviewing, writing about the Novartis case, but perhaps it is time now for us, from the academic circles especially, those who have more time than lawyers, perhaps to look into this genus-species conflicts, to look into how Marcus claims fit into the matrix of Section 3D or the anti-evergreening clause, and write research papers from the point of view of India. Because the funny thing that the two things that I would point out over here, beyond the science, if you look at it, this entire concept of Marcus patents or the genus-species conflict, this entire language of selection patents, genus patents, we have incorporated from US law. There is nothing in Indian Patents Act for or against Marcus claims or for or against genus and species patents. We have simply copied this practice from US laws. And now, unfortunately, our courts are burdened with deciding as to whether this practice is right or wrong, or to what extent it is right or wrong. And secondly, and this is again something very, very peculiar to Indian law, in context of this genus-species patents, there is something known as Form 27 or working statements, which is a specific, unique requirement under Indian Patent Act. There is no equivalent elsewhere. And so under Indian law, patentee has to submit an information regarding working, how much product you have manufactured, licensed, or imported, what is the quantity, what is the price of the patented invention. And all this information has to be given as part of the working statement of Form 27. And in this particular disputes, one catch line, and this is perhaps easy to understand for all non-science, non-chemistry people also, you would be surprised that for the genus and species patents, which are two separate patents, identical Form 27s, identical working statements were filed. The same drug in both the patents, the same composition, the same dosage, everything the same efficacy. And at least at the interim stage of Tika Galore, the single judge decided that how can this be possible? You have two patents covering the same drug, you're filing identical working statements for that. And therefore, the injunction was not granted in favor of the patentee. The trial has still not happened, as I said. And look at the politics of it. Look at the divide between developed and developing countries. In the current US report, Special 301 report, you will be surprised. The US government has blacklisted India or put it on a priority watch list. And one of the facts they are saying is that we have a Form 27 working statement, which is a very burdensome requirement. This should be diluted. And I beg to question why. so that we are not able to catch you? Is that why you want us to dilute these working statements? Number one. And number two, unfortunately, our Indian Patent Office also brought a proposal to dilute some of the standards in these working statements. Form 27. Luckily, that has been recalled now. They will not be moving ahead with this proposal. But the point is that, as one of the speakers in the morning session, inaugural session pointed out, there are many unique elements, including Section 3D and working statement clauses in our Patents Act. Unfortunately, we have been borrowing too much from US and European jurisdictions, forgetting that this law, as Justice Prabha Sridevan pointed in one of her judgments as chairperson of IPAB, we are forgetting that this Indian Patents Act is our act. And this has to be interpreted on the basis of our unique situation. Particularly when in respect of this, your TRIPS agreement is silent and is giving you enough flexibility to maneuver the core of patent law as per your specific requirements in India. So we need to perhaps look into it. Judges need to be perhaps sensitized, and I would really, really recommend that some of you should look into these aspects of genus species patents and working statements. And before I conclude, just one small part that I would like to, one small metric that I would like to point out in context of this working statement and the fact of promoting patenting culture in India. I was looking at the latest report of Indian Patent Office annual report, official government data, and you will be surprised that as of 31st March 2019, last year's data we have official, there were 64,686 patents in force in India, which is a small number. Even smaller, only 9,000 out of 65,000 approximately, hardly 9,700 patents were actually owned by Indians. So we are still doing the same thing. There are foreign companies which are going and obtaining patents in our country and stopping our people from using those products. This very situation, a younger committee sought to remedy by bringing in the 1970 Patents Act. It has not been remedied so far, number one. And number two, related to this topic, working statements, hardly 51,000 Form 27s were filed for these 65,000 patents, and only 14,000 patents were actually worked in the territory of India. What is the use of granting these patents to India if most of them, majority of them, are not worked in the territory of India? What are we gaining? And therefore, my argument and our argument as representatives of generic companies always has been that you have to strengthen your working statement clauses, Section 146 of Patents Act, particularly with regard to Form 27. Do not deal with it in a casual manner. Unfortunately, that is what is happening. It's taken very casually by courts and by IP office. And second thing, we need to, particularly in the context of Section 3D arguments, we need to do something to resolve this genus-species conflict. We need to perhaps, maybe in one of these disputes, if it goes to Supreme Court or a division bench of a high court, we need to have specific metrics of when the species patent comes out of the ambit of evergreening by satisfying enhancement of efficacy, and when the species patent does not do so. So for the first case, you will get the patent. Second case, the patent should not have been granted to you. So I hope that some of you are able to take on this research as part of your academic ventures. And I hope there is a resolution of at least these two aspects in context of Section 3D, the genus species patent and working statements. And I'm extremely sorry if I have gone beyond the time allotted to me. And I will pause over here. And I hope I have been able to, within this time allotted, I've been able to make you understand some of the nuances, especially the science part of it. So thank you so much.
Thank you so much, sir. even though I'm not a science student, I was able to understand the various nuances that you have pointed out. And when it comes to the working statement and in terms of the light of the issue, that is that Indians do not have that many patents in terms of the Indian patent itself. It's an alarming issue which you have very correctly pointed out. I'm pretty sure the students over here and the participants over here will take this up as further studies. Now, I would like to invite upon Ms. Akanksha Kumar, who's a doctoral scholar at NLU Jodhpur and was the former assistant professor at Nalsar. Ms. Akanksha Kumar is an alumnus of Hidayatullah National Law University, Raipur, and has graduated from the Faculty of National University of Singapore, where she has done her master's in international and comparative law. Ma'am has also served as the assistant professor in the Amity University, Chhattisgarh, and at NLU Jodhpur, she headed the Center for Advanced Research in Training and Arbitration Law and handled the activities of the flagship journal, the Indian Journal of Arbitration Law. Today, ma'am shall be speaking about the geographical indications as a tool for upliftment for handloom weavers in India, and the suggestion shall be given for a sustainable use mode. We are really honored to have you amongst here, ma'am. If you are ready, you may proceed with the
all right.
presentation.
So can people hear me and see me? You can just give me a thumbs up, Naveen, or you can just tell me.
Yes, ma'am. Perfect.
Okay, I'm visible and audible, right?
Yes, ma'am.
All right. Good afternoon, everybody. I think Dr. Tandon, as much as I admire him, is it's an extremely hard act to follow. And before I begin, I would like to say that it's a little surreal to be on a panel with somebody I knew 7 years ago. So hi, Parikshit sir. And Devmita and I are both not ignorant to keeping an audience captive when you're right before lunch and the audience is getting a little bit hungry. And I would use visual aids because I believe that what I am about to talk about will require you to look at what I am trying to speak about. Also, taking a cue from what one of the speakers at the inaugural said, that Professor Shamnath, God rest his soul, Professor Shamnath's legacy has been to engage in social activist lawyering and social activist teaching. A lot of what I've been doing over the past couple of years has been to look at how whatever I do as a law researcher and as a law teacher, what social impact can it, positive social impact or positive social change it can bring. So what I'm going to talk about today is something that I'm currently working on. So I'll begin with a caveat that this is an unfinished piece of work. It's a working paper that talks about how the handloom weavers in India are ignored for the larger part, and it is only some luxury weaves, as they are dubbed, that get the requisite government patronage and therefore GI tagging support from the beginning to getting the tag till the end if the end point of a GI is a successful litigation. So this map that you see on the screen, right, this map is something that has been doing the rounds of social media since forever. A lot of it is slightly incorrect, but it does give you the picture of the diverse, if not all, kinds of handloom as well as handicraft weaves that are present in our country today. Not all of them are GI tagged. All right, I'm unable to switch my slides. Right. So in early 2020, the government, the textiles ministry released the fourth All India Handloom Census. Now, according to the figures in the handloom census, the total number of households in India that are engaged in handloom activities, that is both weaving and allied. When I say allied, it could mean that the handloom is then hand embroidered, or it is not done on a handloom but on a semi-mechanized loom, or it is hand braided, etc. So the total number of households is over 31 lakhs, of which 22.5 lakhs, that is almost 89% of these weaver households, are located in demarcated rural areas in India. and nearly 72% of the handloom weavers are female. Now, this becomes very important when you try to look at the usage of an intellectual property tool as an emancipatory or an upliftment tool. Furthermore, across both urban and rural areas, the share of weavers aged between 14 and 18, all right, that is the younger working class, is only 2.4%. And there is a very important reason for this, which I will come to in a while. Now, Peter Drahos, in the book that Professor Calboli edited along with Professor Wilun, he begins with this position, and this is an argument that is used, and it is a part of the EU working paper on geographical indications, that while most intellectual property rights have the promise of economic gain, geographical indications, especially geographical indications for food and agriculture, and with agriculture, obviously in the EU, we talk about wines. For food and agriculture, they carry the grand promise of rural development, right? And this grand promise of rural development is what I wish to tap into when I talk about exclusively handloom weavers. Now, in India, while it is a very encouraging figure to see that as of September 2020, this is as of today morning on the IP India GI registry page, there are 370 granted GIs registered in India, of which 214 are in the handicrafts category. Now, please understand, and this is especially for students who may wish to pursue research into handloom weavers and handicraft GIs later. Handicraft is not the same as handloom, which is not the same as handspun. Now, considering I'm huge on visual aids, for example, I am wearing this maroon dupatta, which is handloom. It was purchased directly from a weaver in Bhujodi in Gujarat during the pandemic to support the weavers. And this is something I will come to later when I talk about sustainable use and weaver upliftment through GI tagging. Handicraft, on the other hand, is if this particular dupatta was, say, hand stitched with mirror work. The mirror work would be the handicraft, but the fabric on this dupatta was weaved on a loom. Hand spun relates to the thread that is used in weaving something. Hand spun is what khadi is. Khadi is not the same as something passed off as khadi but was not spun by hand. So when the thread is done on a charkha, that's hand spun. In spite of all this promise that there is so much GI registration in our country, of which 214 is in the handicraft category, and I'm still in the process of culling out how many are actually handlooms and not merely handicraft, India exports also about 95% of handwoven fabric of the entire world's share of handwoven fabric exports. Unfortunately, in our country, in spite of the current government's Atmanirbharta and the Swadeshi campaign that is currently being pushed down our throats, for want of a better word, there is considerably lesser demand of handloom products in our country. And therefore, it makes the lives of weavers full of hardship. Also, the wages that are paid to the weavers are considerably low. They get a very, very minor per hour loom wage. If it's the Pochampalli Ikat, that's different. But for an unregistered GI weave, still trying to be revived by weaver clusters or by cooperative society clusters, the per hour wages are minimal. Now, something great was going to happen in 2019 nonetheless, when instead of at a state cooperative level or at the state handloom society level or at the state handloom development council, which is the government run council level, instead, even though the National Handloom Day is celebrated on the 7th of August every year, the good thing that happened and should have been seen to fruition if it weren't for what happened this August. So in 2019, the government invited suggestions for a new textile policy. Now, by this time, I was working at Nalsar and was associated with the IPR center at Nalsar. And in fact, we were working to participate as a participate and send feedback on what the national textiles policy should be. And we were actually planning a project which, considering I no longer work at Nalsar, my colleagues are very well handling and taking it forward. So the policy invited suggestions that would envisage positioning India as a fully integrated, globally competitive manufacture and exporting hub. While this is very ambiguous and they actually would have supported powerloom also, because powerloom generates employment, yes, this was further followed by the launch of the National Textiles Mission. However, we moved to 2020, we are hit by the pandemic, and then just stuff starts going wrong. In August this year, the All India Handloom Board and the All India Handicrafts Board were dissolved by the development commissioners for these sectors in late July and early August, right before National Handloom Day, August 7, 2020. This move has drawn very, very severe criticism from those that have consistently worked like the Dastkar Society. And the Dastkar Society, in fact, was very vociferously critical of this move, because the All India Handloom Board was then at that time the only body that allowed a direct voice to handloom weavers, GI or no GI, which is where the argument that I make becomes more important. That all the more now, GI tagging in a public-private partnership style, all right, and this is something Professor Srisudha did bring up. So GI tagging that is handheld and led by the government is something that can work if done sustainably. So the central argument in this working paper is that GI registrations coupled with the right governmental patronage, and by right, the operative word being right, I mean that it's not just the luxury silk weaves, but the more humbler weaves that are done in coarse cotton. All right, and this is something that was there on an earlier slide. So if you notice, this is Mr. Kalyan Sundaram, and this is a portal, it's a vendor, Abhinaya, that launched her startup called Raga. And I work with her quite a bit to comprehend the lifestyle and the mindset of the Tamil Nadu weavers and the clusters that she works with. All right. So the Arupu Kotai weave is not GI tag. And they have a colloquial word for the coarse cotton that they use called maripu. And maripu actually means nothing in an English or a Hindi translation. It's their colloquial word for the coarse cotton that they are using to make these humbler weaves that are much more affordable, and they are done in natural dyes, so they won't harm your body if you wear them for really long. However, unfortunately, no GI tagging. So the methodology that I've used, and it's a currently ongoing methodology, that I'm looking at doctrinal work that has already been undertaken, earlier works by Professor Kalboli in the EU and all her ancillary works, not just this book that's on the slide. Professor Yogesh Pai and Tanya Singla, who've written this beautiful chapter called Vanity GIs in this same book. Soumya Vinayan, one of the older articles in 2011 that she published in JIPR, but her work and building on those works and existing IPR studies on textile industry and how IPR helps in the textile industry, existing sociological work on handloom weavers and their hardships and lifestyles have been used by me, and then coupled with what I am currently doing, which is that I contacted all the handloom vendors, weavers, and clinics that I know of through the beautiful social media network that I have. And this is something that I do want to tell students, that if you use social media judiciously, it's not that bad an idea, but use it judiciously. So I use social media that way. There's a Google form that I've been using. But a lot of the weavers and the vendors are really busy considering Navratri and Pujo season. So I still haven't received adequate number of responses. Nonetheless, this is a very micro level research that does nonetheless span across states, So even though the project began initially as a Telangana only and then expanded to Tamil Nadu and Karnataka because I was located there, now given the pandemic, I have expanded the network of who I'm speaking to and who I'm collecting data from. However, this data set that has been collected by me, and I'm in the process of collecting the data, this is not to really show any trend. This is more to gauge opinions to formulate or suggest a sustainable use model or policy. So the end goals are, one, to identify what these humbler local handloom weaves are that are not GI tagged but are equally representative of the terroir, which is the locality, the land where they come from, as well as the culture that is represented from the region. The second thing that the end goal will try to do is to propose a model for not just seeking GI registration, but also post-registration sustainable development model for the holder or the cooperative or the cluster that is now the proprietor of the GI tag, and then for upliftment of the weaving community. And then also, because this is something that I've been looking at, propose a model for applications for revival weaves. Revival weaves are weaves that were once upon a time worn by the ancient royalty or even way in the past, but are no longer weaved or have only, say, 2 families or 3 families, less than 200 weavers working on them. There is an entire revival project that is being run in Karnataka by this NGO called Punarjivana, and I am trying to work with them to try and get GI tagging for the Gomiteni, which is a Karnataka weave that is currently not GI tagged. And we are at Nalsar, what we were trying to do is try and do the same thing for the Medak district Dubak weaves, which are single weft ikat weaves, which are not done anywhere else in the country on handloom. But since it's a dying weave, there needs to be a revival activity, and they are beautiful, coarse cotton, humbler, affordable, daily wear, and beautiful. Now, the main arguments that I'm leading, and I will take about 3 minutes more to wind up, so please bear with me. The main arguments that I'm leading in this paper are both theoretical and obviously experience-based from learning from others. So the first thing is that obviously the argument does exist that the handloom sector is a goldmine for GI. Like I point out, it has both the terroir and the culture linkage, terroir being local, land, territory, and culture being it's a denoter of a particular identity. Nonetheless, like I said, several beautiful handloom weaves are dying a slow yet very steady death. The reasons for which are multiple, main reasons that have been identified during my research and as told to me by the weavers directly. I am going to redact their identity to protect their privacy. But a lot of weavers who I spoke to directly, especially in Tamil Nadu and Telangana, have this lament that it is only the luxury silk weaves like Kanchipuram in Tamil Nadu and Pochampalli in Telangana that are given the adequate patronage for GI tagging by the State Handloom Development Council, and the others are not. Another thing is that because of the lack of awareness of the economic benefits of getting GI tagging and then exploiting the GI tagging to its fullest sustainably without resource depletion is something that so many weaver clusters, in spite of the cooperative society existing, in spite of NGOs trying, in spite of vendors trying, they are not aware of the economic benefits that GI tagging and GI exploitation coupled together can bring. Which is why very often the weavers are now very old with weakening eyesight. And the younger generation, and this is something I pointed out in the beginning, does not readily choose handloom weaving as a career option anymore or even as a job. They prefer doing a job that will bring in easier, faster money. So the theoretical argument for nonetheless getting GI tagging for the handloom sector is that it nonetheless helps in establishment of a niche market. It generates and it denotes a premium quality even for a humbler weave. All right. and it helps consumers associate in their mind a quality. So even though the GI performs a function like a trademark, it does something more, because it doesn't just denote quality, it starts denoting quality of a certain origin. All right. Nonetheless, please, I do accept that while I propose that GI tagging is a great idea, there are costs associated with GI tagging with respect to maintenance of the GI. Furthermore, GIs are not just an important tool, like I said, of economic advantage. They are also an important tool of information to the consumer if the particular geographical origin is related to a method of production. Let us say the naturalness. For example, the Kosa silk is actually treated with potash alum, again a natural material, to give more beauty benefits to your skin. All right, the Kosa silk is a registered GI from the state of Chhattisgarh. GIs furthermore play an important role in disclosing environmental impact because of the geographical origin. So, for example, the Kosa, again, I know more about Kosa because I worked with the people who eventually got the GI tag for Kosa. Now, Kosa is actually an ahimsa silk, which means that it is the abandoned cocoons of the silkworms that are found on the mulberry trees that are used. So it's not
Bhargavi, can you hear me?
Yes, sir, you're audible.
Hello, am I audible? I'm visible.
Okay. Navneet, hello. Navneet,
Yes, ma'am.
there is some power cut technical issues from the side of Avansha ma'am. So she had asked us to proceed with the next speaker.
Perfect, ma'am. Perfect. Okay, so coming up to the final speaker for the first plenary session, I would like to call upon Ms. Devamita Mandal, who is the assistant professor at HNLU Raipur. Devamita ma'am has completed her LLM with specialization in intellectual property laws from Nalsa Law University, Hyderabad, and has done her BA LLB from Kanungo Institute of Industry and Technology, School of Law, Bhubaneswar. Ma'am was recently awarded the full sponsorship by the WIPO Academy for participation and paper presentation in the second Intellectual Property and Innovation Researchers of Asia's conference, which was held in Indonesia. Today, ma'am shall be discussing about the dilemma of digital exhaustion, which is in terms of exhausting copyright holders in digital markets. And we are very honored to have ma'am's presence over here. Ma'am, if you're able to turn on your camera, we shall proceed.
Can you hear me?
Yes, ma'am, we can hear you.
So the irony is that I'm the last presenter, and by now everyone must be facing the digital exhaustion as well as the hunger and everything. So I'll keep my presentation to be very short and crisp so that I just discuss the bullet points with you, and then we'll be done for this plenary session hopefully quickly. So my presentation for today is Dilemma of Digital Exhaustion, Exhausting Copyright Holders' Rights in the Digital Market. So, okay. We already know the principle of exhaustion. So when we talk about the principle of exhaustion, it is intrinsically linked with the doctrine of first sale. That is, once a copyright holder legitimately puts his goods in the market, he exhausts his rights in regards to that copy of the product containing IP rights, and he cannot thereafter regulate or control the subsequent buyers or sellers or buyers of the good per se. So that is exhaustion of the intellectual property rights as we understand in physical world. Now this principle of exhaustion is a limitation on the right of distribution of the copyright holder in particular, and therefore when we talk about right of distribution, we understand right of distribution again connected with physical tangible copies only. So basically by legitimately putting the good first in the market, the copyright holder exhausts rights in regards to that copy which has been legitimately put. If not put with the consent or with legitimate interest, then that copy, the rights over such copy is not exhausted, and such putting in the market may amount to infringement of the copyright also. Now, when we talk about the types of exhaustion, there is national exhaustion, there is regional exhaustion, there is international exhaustion. National being the rights getting exhausted domestically within the boundary of a country, regional being within a region, for example, the SHARC nations. Then we have international exhaustion, which is where the market is taken to be the global market, and therefore putting the goods anywhere in the global market amounts to exhaustion for all parts of the globe. Coming to what is digital exhaustion. So digital exhaustion is basically trying to apply this principle of exhaustion to digital copies of goods per se. So my paper or my work is in relation to what are the dilemmas, or are there any dilemmas in applying digital exhaustion principles to digital copies. So some of the issues which I have recognized, which I've termed as a dilemma of applying digital exhaustion is first, whether there is actually a sale in digital space of content. So for example, if I talk about an ebook or let's say a software per se, though we think that we as a customer is buying the copy of the book, what we get is a technical copy of the original book. Or when we buy a software, when we say we have bought the software, we are not actually buying a software, we are getting a license to use the software for let's say 5 years, or for even if perpetual, or what we call to be lifetime software, lifetime antivirus or something like that. So none of them actually satisfy sale in regards to what we understand sale in a physical world. For example, so parallelly you can see here I've quoted the Usoft versus Oracle judgment of the European Court of Justice. I'll quickly go to that judgment. So here Usoft platform which used to buy the softwares from the original licensees of Oracle. So these original licensees were legitimate buyers of the Oracle's multi-user packet license. Now, while they were buyers of the license per se, and it's not a sale. But surprisingly, in this judgment, the European Court of Justice held that the software, like the transfer of the copyright by the copyright holder to the customer of a copy of a software
accompanied by the conclusion between the same parties of a user license agreement constitutes first sale. Now, however, if you see, sale and license are different things. Sale is complete transfer of ownership, whereas license is a permission to use. Surprisingly, though, and this judgment has been fairly criticized also by many scholars across the globe, the European Court of Justice held this to be a conclusive first sale and therefore exhaustion of rights by the copyright holder, that is Oracle, over the software. Also, another interesting point is that it did not take this transfer from the Oracle to a licensee to be communication of the software, but rather it took it to be a distribution under the software directive, because they said that the software directive, EU software directive, was the lex specialis in comparison to the information society directive, which was the general law. Coming back to the second dilemma, so when we talk about a book, let's say I buy a book, if I want to read the book and if I read it repeatedly, after 1 year, there will be some wear and tear of the book, right? That's how a physical copy is subject to wear and tear, and there is deterioration in condition of that particular book. But in digital space, if I buy an e-copy of a book, that book is a perfect substitute for future copies or new copies in the market. So that book is a competition or is a competitor for new copies in the second-hand market. So that's how there is a posed a harm to the rights of the copyright holder when we talk about copy in digital space, and therefore maybe if exhaustion happens, then right holders will no more be able to sell any further copies, because all once exhausted copies will be in the second-hand market and competing with any new copy from the copyright holder. Another important point, another important dilemma of digital exhaustion is that when we talk about this transfer, so let's say I transfer a file digitally to you. Each of us has one copy. So it's not like by transferring my copy cease to exist at my end. We both start having each one copy itself. Just like idea, or the example of idea, like changing ideas per se. So both continue to have one copies per se, and therefore the original copy is always retained with the initial acquirer from the copyright holder. However, if I buy a book from Oxford and then I sell it to someone, then I no more have that book with me. It's only the subsequent seller who has the book. So this is another conflict between principle of exhaustion in physical world and that of the digital world. So here there are two more cases which highlights these problems. For example, the Capitol Records versus Reed-Eggy case. This is a US case where Capitol filed a case of permanent injunction against Reed-Eggy, who was providing this service where they used to buy the music files which are legitimately obtained by a user from iTunes in the Reed-Eggy's platform at a much lower rate, at a much lower rate per se. So Capitol filed this infringement case saying that Reed-Eggy cannot do it because they hold the copyright for those songs. Whereas Reed-Eggy said that we have bought legitimate copies, so which has been legitimately placed by the copyright holder to our licensee, and the licensee has sold it to us, and these are verified legitimate copies per se. Capitol said that exhaustion principle doesn't apply here because even the licensee who bought the copy, while transferring it, is actually reproducing. And Reed-Eggy is helping in such reproduction. So there was a comparison between reproduction right and distribution right. And while Reed-Eggy was trying to say this is distribution right can no more be exercised because it has been legitimately bought and it was legitimately sold by the proprietor also, Capitol is saying is that it's not the distribution right which is in question here, the reproduction right is in question. And there is no exhaustion of reproduction rights till now principally recognized. There is a justification for the same also because we know that copyrights are exclusive rights or exclusive rights given to the holder so that they can commercialize further and get the incentive of creating more work. So if reproduction has exhaustion as limitation, then the owner cannot any further exclusively reproduce. That means he cannot gain economic benefits or revenues out of the work per se. So exhaustion has not been recognized
exception or limitation or right of reproduction. And therefore, in the capital judgment, however, the US Second Circuit Court said that there is no exhaustion of a digital music file per se, and these all amounts to copyright infringement. There is another case. This is the recent case of term cabinets, which gained a lot of attention. This is the 2019 judgment. So this was about e-books. And this is a particularly important judgment because, and I totally agree with the judgment, because whether we talk about e-books or we talk about, let's say, software, or we talk about music files or movies or whatever, so in this judgment, the ECJ, the European Court of Justice interpreted that these are not goods per se. So they are not property in the sense of goods, but they are actually electronically supplied services. And therefore, like recital 29 of the Information Society Directive says, the question of exhaustion does not arise in case of services, it arises only in case of goods. So even if an ebook is downloaded, let's say I buy a book from Amazon, I cannot sell the book to a subsequent person. Apart from the technological barriers which are there, even if the technological barriers were not there, I cannot legitimately sell because I have not bought the book as a good, but as a service to read the book for forever. Like because I bought the book, I have the service of reading the book. Similarly, when I buy a software, the software is transmitted to me or communicated to me so that I can use it for, let's say, 2 years or 5 years, or if it's lifetime, then for lifetime. So it's a service being provided to me, and there is no question of exhaustion. Now, coming to India, because there was not much material on India, so I tried to look into the provisions of the Copyright Act itself. So when we look into these points, particularly for software, softwares are considered literary works in India also. But however, section 14B clause 1 says that, clause 2, sorry, says that the owner of a software has a right to commercially rent and has a right to sell. Now, if the owner has a right to sell, that means the right of resale will be in contradict of the right to sale, which explicitly means that, which can be induced as that, computer softwares in India cannot be subject to principle of exhaustion, whether physically or digitally. The second point is literary works, ebooks as literary works. So there, if you see, in physical world, books are considered to be subjected to the principle of exhaustion because they are copies already in circulation according to section 14 clause AI. However, if we take the term cabinet interpretation, then ebooks are a service and not a good, and therefore they cannot be subjected to the principle of exhaustion. Then third comes the category of films and music which we buy online. So we already have the Warner Brothers Entertainment versus Santosh judgment, which has specifically said that these are like cinematographic films and sound recordings form a separate set from the primary categories of work like literary work, dramatic work, and other things. Therefore, being a separate set, they are having the same kind of right, that is right to commercial rental and right to sale. And therefore, we can conclude that there is no principle of exhaustion applicable even on sound recordings and films per se. The only point of gray or the period where there is a gray space is regarding ebooks, because India doesn't have a parallel to the Information Society directive in EU. We do not have any law which says that ebooks are services. So it's on the Indian courts to interpret. If they interpret ebooks to be a service per se and not a good, then maybe there will be no doctrine of exhaustion applicable even in digital world for this. So that is my conclusion. I've reached the end of my presentation. That's all. So if anyone has any questions or any suggestions.
Thank you so much, ma'am. So the situation that we are in right now, we have sent a message to all the participants that all the questions that they have regarding any of the panelists will be sent to Team CIPRA's email ID, and we'll forward the same to you, and so that there can be a conversation. On that note, I would like to thank you so much for the wonderful presentation. I would like to again invite Ms. Akanksha.
Navneet, can you hear me?
Yes, ma'am, I can hear you.
Why am I unable to share my screen?
Ma'am, I think you can try now. Ramesh sir, can you
One
make
second.
ma'am one of the yes?
Yeah. Can you see it now?
Yes, ma'am.
Right. So I was telling you about the terroir and the cultural linkage. I'm so sorry. So it's erratic weather with power cuts. So I'm really sorry about that. Yeah, so I was talking about the terroir linkage and the culture linkage and talking about how terroir and culture can be monetized. And it's not as if it's not been done in the past. It is being done very effectively with Kosa, which is a more humbler weave. And the Kosa story is what became the inspiration behind this work. Furthermore, like I was saying, GIs are a very important cultural identity tool and regional identity tool, especially in the northeastern region of India. And in fact, a lot of prayer meets have them looking at and bending over a hand woven cloth. Hand woven cloth is given to family elders at celebrations. So it's an important denoter of cultural identity also. Now, some of these were my theoretical doctrinal findings. Some of the empirical results are in fact very interesting. So I have only received 11 responses till yet. And quite a few of the vendors don't really know whether the weaves that they are selling have GI tagging. Furthermore, you will notice that quite a few of the weaver communities or the vendors also don't know whether their weavers know about GI and whether they should be educating their weavers about GI tagging. Other interesting responses to a question that I had asked was that are there any revival weaves that are not GI tagged? And somebody responded that Chhattisgarh weaves are, according to them, not GI tagged, which is quite alarming that if there is a vendor that is purporting to sell geographical indication tagged varieties of weaves on a social media handle, they believe what they are selling is not GI tagged when it's actually a GI tag, because Chhattisgarh weave, the main Chhattisgarh weave kosa, is actually GI tagged, right? And a lot of them are even, and I noticed that the ones in red, the ones that they say no, are actually selling GI tagged on their pages. So they don't know what they are up to, and which is why the immense lack of awareness and general apathy as a whole has become a problem with upliftment through GI as a tool. Now, all of these challenges are something that I explained in the beginning also, that there is presupposition of a collective action in GI registration under our law, and that there will be no rivalry. But unfortunately, within weaver clusters of the same kind of handloom meat, there is rivalry as to design, because designs win national awards. So it's a little it's to assume that there is no weaver rivalry at all. Furthermore, there are costs to registration. Like I said, government support is mostly to luxury handlooms. Weaves are dying. Weaver payments are extremely low, especially more so in the time of this pandemic. A very, very important problem is power looms and how power looms are passing off their output as handloom. They are cheaper, and therefore the consumer seems to gravitate towards the cheaper, more affordable product rather than the traditional product. And speaking of tradition, a very important handicap of handloom weavers that I have been able to gauge from the responses received from my dataset respondents is that very often the younger consumer crowd thinks that traditional handloom designs are very old and are not catering to modern tastes. And which is why you will not see a younger crowd purchasing traditional handlooms, which is gradually changing because of social media networks and what we call in our social media language the sari sisterhood. So the tentative conclusions, and this is where I'll end, and this is something that Professor Srisudha pointed out in the beginning about the SDG 17. Can the SDG 17, which is public-private partnerships and how MSMEs and SMEs have been given patronage by the government, can that be done for GIs? It is not unheard of. Like I said, the Kosa weave is something that is being handheld by the Chhattisgarh government. The Pochampalli Ikat is patronized by the Telangana government. Bandhani is patronized by, which is handicraft, not handloom, but I'm giving you an example, is patronized by the Gujarat government. Furthermore, a very important tool is designated weaver upliftment funds. Now, these designated weaver upliftment funds need to be coupled with GI registration and GI sustainable use support. Again, it's not unheard of. As of last year, Andhra Pradesh Chief Minister, then Mr. Jagan Mohan Reddy, launched the Netana Nestam campaign. And in fact, there are pictures of him trying out the looms at Dharmavaram in Anantapur district. So, furthermore, very, very important, the focus doesn't need to just be on the GI tagged handloom output. It also needs to be on raw materials. For example, the Chinal Pattu, they have applied for GI tagging. The Chinal Pattu uses banana fibers to make silk. But however, if you don't grow enough banana plants, you will run out of the fiber. So that needs to be at every stage a sustainable model to further economic monetization of GIs. Furthermore, just because the national boards have come to an end doesn't mean that the state boards can do nothing. In fact, the state cooperative should take a more proactive role. And for another interesting thing is combination IP, that along with GI tagging for the weave, there should be a trademark registration of the seller or the curator, coupled with design protection for limited edition designs by weavers that are innovating with tradition and offering modernity. The best example of this is Mr. Manas Khorai. He's a national award-winning weaver and designer. He works directly with the weaves and knows how to operate a handloom himself. And he has these beautiful innovations that he's done on balucharis, banarsis, and the bomkai. Certification marks are another very important tool coupled with GIs. Now, even though we don't like Fab India anymore because of how it was passing off khadi, passing off power loomed fabric and other hand spun fabric that wasn't khadi as khadi, Fab India uses something called craft mark, which is a certification mark for Indian handicraft and handloom that is sold in Fab India. Another important thing that can, should, and needs to happen is reform in the GI legislation itself. And this is a proposal that does build on an earlier proposal by Professor Yogesh Pai, wherein they've argued that the Indian GI legislation is too much like the trademark legislation, wherein it focuses more on the trader and not the producer. And our legislation needs to be slightly more like the EU law, not excessively protectionist, but more producer centric to incentivize weaving. And our role as learners, teachers, universities, and consumers is to support the weavers first and foremost, if we can afford it, through purchase. Preferably try and purchase from the weavers or from trusted vendors. Through capacity building as universities, like I said, Professor Gargi, who will be speaking at the next session, she's doing some brilliant work with the FDDI, which is the neighbor institute to NLU Jodhpur in Jodhpur. And they're doing some amazing work with the handloom and handicraft in Rajasthan. Nalsar and the pilot project that I talked about the Medak Dubak weaves through the Nalsar IPR Center. IPR centers can actually turn into these GI incubators within their state-specific locations and actually help registration as well as, more importantly, post-registration sustainability of GIs. And with this, I finish. Thank you so much for giving me a second opportunity to finish.
Thank you so much, ma'am. It is indeed our honor to have all the panelists today here with us. I would personally like to thank Dr. P. Srishudha, Sam, Dr. Parishit Siroi sir, Dr. Victor Vaibhav Tandon sir, Dr. Varsha Deshmukh ma'am, Ms. Akanksha Kumar, and Ms. Devamita Mandal for spending time and being a part of this national symposium, and would like to give the guarantee that Team CIPRA at Symbiosis Law School Hyderabad would be willing to take up the research in terms of the subject matter that you've discussed today, and we'll try to ensure that this work can be furthered on our end, or in terms of any research or in terms of any assistance. On that note, I would like to once again thank every panelist and every attendee for being a part of this session. If there are any remarks from the panelists, we would love to hear them. Okay. On that note, I would like to end the session. Thank you all for staying with us. I hope you all can have lunch right